Good afternoon. Good afternoon. Today is January 28th, and welcome to the bill hearings for the Ways and Means Committee. I would first like to start off by congratulating our new Local Revenue Subcommittee Chair, Melissa Wells. So if anyone who is listening or watching, I should say, if Delegate Wells, Madam Subcommittee Chair, speaks, unfortunately, it will say the wrong name on there, but we will work with IT to get that fixed. Briefly, I would also, I've been getting some commentary and questions, so I would like to remind folks of our policy on sponsor-only oral testimony bills. This is not a new policy since I became a chair in 2021. This has been our policy, and it is the policy because this committee, this year so far, and I think all years except last year, have had the most amount of bills in the House of Delegates. So if it is an exact reintroduction of a bill that we heard previously during this term, we will have sponsor-only bills. That does not mean individuals cannot submit written testimony. You can submit written testimony through the My MGA system, and you can do that whether you support or do not support the piece of legislation. What we have been instructed by ITO, which stands for Information of Technology Office. What they have instructed us, what you cannot do on sponsor-only bills is say that you support or do not support a bill without written testimony. So if you want to support or not support a bill, you have to submit written testimony. It can be one line, and that's perfectly fine. We also do not time the sponsors. That is certainly still in my discretion, but as of right now, we do not time sponsors on sponsor-only bills. So that is the policy of this committee. And with that, we will call House Bill 59, and Secretary Day, you can come up with whoever you would like to bring up with us. Welcome back. And we don't time secretaries either.
Well, Madam Chair, Madam Vice Chair, members of the committee, thank you so much for that, and thank you for having us again. For the record, my name is Jake Day. I'm the Secretary of the Maryland Department of Housing and Community Development. I want to thank the Chair for sponsoring this legislation on behalf of the department. You have our written testimony, I believe, in front of you, but I just want to highlight a few key points, and then I'll hand it over to my colleague, Deputy Director Yeager. House Bill 59 proposes alterations to Maryland's property tax sale procedures to better protect vulnerable households from foreclosure. Essentially, the legislation would prevent most residential properties from going into tax sale foreclosure because of unpaid taxes or utility bills, and provide distressed homeowners more options and time to pay their debt and keep their homes. One of the department's core objectives that I've talked about since I took this job 2 years ago is to provide shelter for all. It's a principle that we apply to everything that we do. And to meet that objective, we need to build more housing, more affordable housing, and we certainly plan to do that in support of the governor's economic agenda. However, it's equally important to help keep people in their homes. Last year, the General Assembly wisely, I think, passed the Renters' Rights and Stabilization Act to better protect renters facing eviction. In a similar vein, this bill will protect homeowners facing foreclosure. No one should lose their home over a relatively small unpaid water or electric bill or a fairly small amount of property taxes, less than $1,000. And if faced with that challenge, a homeowner should have ample time as well as defined and affordable procedures to pay their debt and to keep their home. While owner-occupied residential properties represent only a small fraction of all the properties that go to tax sale, their owners are often elderly, they're often disabled, they usually live on low or fixed incomes, and they are disproportionately African American. Earlier, I referred to $1,000 in property taxes as quote-unquote fairly small, but for the majority of these distressed homeowners facing tax sale, that amount is not small. Nor are there potentially unpaid utility charges. nor are the expenses associated with redeeming a property that has gone to tax sale, which can routinely cost additional thousands of dollars for these homeowners. In some jurisdictions, interest rates for redemption can be as high as 20%. If they're willing to pay off their debt, they should have the time and the opportunity to do so, and they should be able to do it without additional overly onerous fees. If they can't pay the debt all at once, a payment plan should be developed and regulated by their local government as an available option. We all understand that property taxes are an important source of revenue for local government. I want you to know, as a local government official for 10 years, I know firsthand how important it is. And this bill respects the authority of local government. It does not target that revenue stream, again, which is critical for local government. But House Bill 59 also does not prohibit a locality from pursuing foreclosure actions on vacant or abandoned properties, which is increasingly burdening many of our communities. In fact, it provides local governments with more flexibility in dealing with abandoned property by authorizing them to offer abandoned property at a starting bid of less than the value of taxes owed. And House Bill 59 does not prohibit the foreclosure of tax sale of an owner-occupied property. It just alters the process and offers additional protections for vulnerable homeowners to keep them in their homes. Extending the amount of time before a foreclosure action can be filed, capping interest rates of property tax redemption, freezing the amount owed at the time of tax sale, and providing homeowners with the ability to enter a payment plan rather than being required to pay the entire redemption amount all at once will help protect some of Maryland's most vulnerable homeowners in a very, very dire situation. So for those reasons, Madam Chair, I respectfully ask the committee for a favorable report on House Bill 59. Deputy Director Yeager.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Bob Yeager. I'm the Deputy Director of the Department of Assessments and Taxation. I'd like to thank Secretary Day for his leadership on this important bill, which furthers the governor's goal of making Maryland an affordable home for all residents. I'm here today to speak in support of House Bill 59, which aims to enhance Maryland's efforts to assist homeowners who struggle to pay their property taxes, avoid tax sale, improve their financial circumstances, and ultimately retain their homes. HB 59 is based on SDAT's firsthand experience working with homeowners through our State Tax Sale Ombudsman's Office and the Homeowner Protection Program. Importantly, I want to emphasize that the implementation of this bill would have no fiscal impact on the state. So let me take you through the key provisions. First, additional time for homeowners. The bill provides an additional 3 months for homeowners to access relief resources before foreclosure proceedings can begin. Second, capping interest rates. It would cap the interest on unpaid property taxes after tax sale at 10%. Currently, counties can charge up to 20% interest. Third, increased threshold for tax sale. It would raise the debt threshold required to be included in tax sale to a minimum of $1,000. Fourth, exclusion of water and sewer charges. It would remove properties with only unpaid water and sewer bills from the tax sale process. Fifth, reducing the redemption amount. The bill would exclude any non-delinquent taxes from the payoff amount. This makes it easier to redeem and potentially makes the difference between saving the home or losing it. Sixth, enhanced foreclosure notices. The bill requires that a copy of any foreclosure notice for an owner-occupied property to be sent to the State Tax Sale Ombudsman's Office. This allows us to proactively reach out to homeowners and offer assistance. Additionally, the bill mandates that tenants living in foreclosed properties receive 90 days notice to vacate, up from 30 days. And it requires notices to be sent by certified mail and posted on the property within 1 day of the mailing. Seventh, extended time for investors to take possession. It would extend the time frame for an investor to take possession on a foreclosed property from 30 to 90 days after the foreclosure. This again gives homeowners more time to take action. Eighth, support for estates and heirs. The bill would broaden the definition of homeowner to include a deceased homeowner's estate, personal representative, or heirs entitled to inherit the property. This would ensure that families have the opportunity to keep their homes even after the owner has passed away, thus fostering generational wealth and preserving family homes. Ninth, record retention. It would require counties to maintain their tax sale records for at least 3 years. This ensures transparency and accountability, as well as preserves data for the State Tax Sale Ombudsman's annual tax sale survey. And finally, vacant and abandoned properties. HB 59 would streamline the tax sale process for vacant and abandoned properties. This would help local jurisdictions with their community development efforts, foster stronger neighborhoods, and increase housing availability, as well as local tax bases. In conclusion, HB 59 offers meaningful reforms that will provide critical reliefs to homeowners in tax sale while ensuring fairness and protecting both homeowners and renters. It would help homeowners retain their homes, rebuild their financial stability, and foster community resilience. Thank you for your time, and we respectfully request a favorable report, and I'm happy to answer any questions you have.
Thank you. We will start with Delegate Buckle.
Thank you, Madam Chair. So I guess a question I would have, having done some of this in my capacity in my professional life, is one provision of the bill, I'm taking a look at the fiscal note on page 3, where it says, right now in Baltimore City, taxes, interest, and penalties that accrue after the date of the tax sale, after the date the certificate holder purchases the certificate, are not included in the redemption payment amount. You're extending the time for a year from the date that you acquire the certificate to when you can file to foreclose the right of redemption. In my experience, I think most people would agree with it. It's usually somewhere between a 4 to 6 months fast, maybe 8 to 12 months until a court actually forecloses the right of redemption. You have the right to take title. So you could get 18 months to 2 years of a tax period where the property taxes are accruing. Who's paying them? Because if you want to come in, if I'm the owner and I want to come in during that period, I've waited 18 months. It's the day before the court filing or the court hearing. I can pay it off. When I pay it off, I've now got 18 months of accrued property taxes. Who pays those? It goes back to me, so I have to pay them? Because what has normally happened traditionally is that if you want to, because you didn't pay your taxes in the first place, if you want to foreclose the right of redemption and be back clean and green, as they say, you have to pay off all the taxes. Who pays these under the new process because it's being so stretched out?
Sure. So the redemption amount, as they calculate that when you go in to redeem, if you're at whatever stage in the process, foreclosure, it would include any accruing taxes except those that are non-delinquent. So let's say you're going to redeem in September. Those taxes are due, but they're not late yet. So those taxes wouldn't be included in the payoff amount. Okay. It would allow someone to redeem at a lower price. Those taxes are still going to be due at some point. It just doesn't prevent them. It doesn't, it's not added to the total bill they have to pay when they're redeeming.
And I guess that follows my question of, is there any statistics that you're aware of? I think sort of anecdotally, a lot of properties that go into tax sale have gone into tax sale over and over again. A lot of them are simply, unfortunately, people who, I have a theory that our property taxes are too high in the state of Maryland and our assessments and taxation go up all the time and our economy doesn't grow, which the governor has agreed with. And people can't afford to stay in the house that they bought 20 years ago because, we're just out of control with respect to property costs and property taxation. But do you have any evidence or any statistics to suggest how many of these places they get redeemed and then they fall back in to the tax sale either in the next cycle or a fairly close cycle?
I'd have to get back to you on the repeat situation. What we've found in the tax sale ombudsman's office, we do outreach to homeowners that we've worked with. So that ranges between 2,500 to 4,500 people a year. We found that if they've received assistance through our office, they've not only been successful to get out of tax sale, but they stay out in subsequent years. So that's a really important resource that we want to connect people with. But for people who are struggling to pay their taxes, we would try to connect them with, there's the homeowner's property tax credit. If you're in a situation where you're low income, you can't afford your taxes, that's something where the state is going to pay part or all of your property taxes on the homeowner's behalf. So that's an important resource. I think if you are in a property that, like you said, is something where the taxes are potentially not affordable in the long term, that's where we would try to connect someone with a housing counselor where they're going to take them through what are their housing needs, what are their current, we hear that when people are in sort of a large family home that everyone's moved out, they're by themselves, they're in this property where the taxes are high because it's a large property. We don't give that sort of advice about what's the appropriate size property. We'll connect them with a housing counselor, and the counselors have shared with us, often that conversation is about what's the appropriate size house, what's the tax bill that you can afford, what's the credit that you're going to be eligible for in relation to your tax bill. So we try to help people through those decisions so that they're in the right place for their expenses.
And Madam Chair, just the very last question I have. A lot of these, I won't say all because it's obviously a sort of an omnibus bill with a lot of different provisions, but a lot of these attempted reforms have already been enacted in Baltimore City. We're kind of taking Baltimore City's model and applying some more of it to the rest of the state. What's the result, or what has the result been in Baltimore City in terms of their ability to collect their property taxes? We're all talking, we're in an age of budget deficits. And so an important element of that is your ability to collect the taxes that are due. Have these reforms or changes altered Baltimore City's ability to collect their taxes? Meaning, we used to get 30 million and with all the provisions trying to help people, which is a great thing, try to keep them in their house, but now we only get 20 million. I'm just using that as a completely random hypothetical. Is there any evidence that the department or the advocates for the bill can say, how did this affect Baltimore City's ability to pay its bills through its property tax assessments?
I think in Baltimore City, when they made these deadlines more generous and thresholds higher, the idea was to help homeowners have additional opportunities.
Sure.
The data from the past several years would be interesting to look at, because what Baltimore City's done is they've removed all owner-occupied properties from their tax sale process when under a certain threshold. So that's going to have an impact on their revenue. We've, like SDAT, the Ombudsman's Office reaches out to the homeowners who were removed from tax sale and try to make sure they're connected with those resources. But what we're trying to do statewide is to give people that additional time, which from our experience, when people reach out to us, it's still a struggle. Even though it seems like 9 months is a long amount of time, they may have several things that they have to go through in order to get the bill paid. They may have to change the deed to the property. They may need to apply for tax credits or loan programs, and that takes time. And so we want to maximize people's chances to use these resources that are already there, all these great programs that have passed through this committee. We just want to make sure they have access to those, and time is often the element that stands in the way.
Okay. Thank you for the information. I appreciate it.
Delegate Hartman.
Thank you, Madam Chair. So my understanding is this would remove from the list anybody that has just solely water and sewer charges, no back taxes. It would remove them from the list of the potential of their home being auctioned or foreclosed on, correct?
Yes.
So what tool would municipalities or counties have to collect water and sewer? What's left if a home can't be sold for those charges?
Yeah, so my experience in local government was we often used collections to pursue those dollars without the leverage of the property, but we were successful. We were frequently successful. We also had a payment plan process. Now that was not mandated, but in law at the time that we had to have that option, but we did have that option. There are also mechanisms to force the issue, right? With simply controlling access to water and to stopping the bleeds, so to speak. So it's different from taxes in that sense. And so I think there's a variety of tools available to local government to address that particular issue, but using collections is, through a private contractor is how the city of Salisbury did that work. It is a tool.
So, Secretary, are you suggesting that it would be wise for a municipality to turn off the water with the family living there versus taking action like this and have them in a house with?
Well, those two things are inseparable in that is always a mechanism that local government can use and often does use, in most cases will use, to address non-payment of water. So it's really not, it's not something that's debatable at this point. That is a tool that any water provider is going to use to address the issue of non-payment.
And then for a house that has a minimal value and is abandoned, not having that ability to sell the house, do you think that the municipality is going to have the same ability to collect if this tool goes away?
Well,
in some of those extreme cases.
But in fact, this legislation on abandoned and vacant property, this legislation would enable the municipality or the county to sell the property when the property is deemed vacant or abandoned.
For only water and sewer?
I got to get back to you on that.
That was my concern. For the water and sewer component only, without a delinquent tax bill, I thought that tool was taken away.
Let me get back to you on that, and we'll get you an answer.
Okay, I appreciate it. Thank you.
It's a fair question. We'll get back to you.
Thank you.
Delegate Miller.
Thank you, Madam Chair, and thank you for bringing the bill. I was reading about the part about the changes to the estate and the definition of homeowner, can you explain like how the current process is and what impact that has had on families? And then just briefly go over the relief again that will be provided to them.
Sure. So currently, if a property owner dies and then their property goes into tax sale, there's a limit to the relief resources that would, the heirs wouldn't have any rights to the relief resources that would be available. This would open up the availability of those resources and allow that person to access the resources. There would be a procedure in place for if you were the surviving spouse, for example. The way that works is if that person is on the deed, then we would transfer the homestead over to that surviving spouse, and that person would be able to receive the homeowner's tax credit, for example. They could go back to prior years. If it's an heir to a property, they would obviously have to go to an attorney or provide some sort of documentation to show that they are the likely heir to this property and show that that the property would be theirs effectively once it goes through the probate process, and they would have access to the same benefits to access relief resources for the property.
And would they have to be intending to live there?
It would have to be owner occupied.
Owner occupied. Okay, thank you.
Madam Chair, can I round back to Delegate Hartman's question?
Yes.
Just really quickly. So to answer your question, you are correct that a vacant or abandoned property, as written, what this would do is if they only owed water or sewer, only owed a utility bill, then yes, this would remove the ability of the municipality or county to sell the property in tax sale on if that was all that was owed. I would just also note, my perspective, and we can do a little research on this for you, is that would be a very rare circumstance that a vacant or abandoned property would owe a water bill and not have a tax bill. But we can look to see if there are any examples that we can cite.
Okay, thank you both very much.
Thank you, Madam Chair.
Thank you.
We'll call up the next 5 in support of the legislation. Allison Harris, Nanika Namdi, Claudia Wilson-Randall, Cortland Merkel, Shayna Roth-Gormley. That should be 5 people if everyone's here. Okay, can we just work our way down and everyone will have 2 minutes?
Great, thank you. Hi, good afternoon. I'm Allison Harris, Director of the Home Preservation Project of the Pro Bono Resource Center of Maryland. I'm here as a legal services provider of tax sale services to low-income homeowners in Maryland, and I'm the co-chair of the tax sale work group that's been working on this issue for about 10 years. I support HB 59, which contains numerous provisions that will lead fewer homeowners to go into tax sale and increase the number of homeowners who will be able to redeem if they do find themselves in tax sale. I support this bill as it is currently drafted with the provision intact that provides that residential properties cannot go to tax sale for water bills alone. Last year, this bill went sideways when that provision was amended to limit that protection to owner-occupied residential properties. There are efforts underway once again to amend this to limit that provision about the water bills, but I am here today to strongly encourage you to support the bill as it is currently drafted, protecting all residential properties. The good people at DHCD and SSTAT made a deliberate choice to protect all residential properties in the language they used when drafting this bill. We know that owner-occupied residential property does not include all properties at risk. The database of properties used to determine which are owner-occupied or not contains numerous errors. There's a lot of reasons for this, including tangled title properties, heir properties. There was an issue in Baltimore City for years where they were not providing the proper information to SSTAT and properties were defaulting to non-owner occupied in the system. As a provider of direct legal services in Maryland for years, my experience is that you cannot cleanly carve out owner-occupied properties from the database. There are too many errors to identify which properties are owner-occupied or not. I support HB 59 in this original form. Thank you very much for the opportunity to testify today.
Good afternoon. My name is Nika Namdi. I'm the Executive Director of the SOS Fund and the Founder and Chief Operating Officer of Fight Blight Be More. And in both capacities, we work to stabilize housing outcomes and help people really regenerate their neighborhoods that have been heavily affected by blight. We support House Bill 59 in its unamended form, as it will extend important protections to Marylanders from tax sale. These protections are key to ensuring that homeowners aren't forced to choose between buying food or medicine or paying their property taxes to avoid tax sale. We are currently working with a 90-year-old widow who fought cancer and fought COVID and was not able to pay their property taxes in a timely fashion because they were hospitalized. As a result, her husband passed, and she has not been able to access the homeowner protection program because of the definition of homeowner. And so this particular bill, extending those protections to heirs and to the estates, is really important, and is why we are asking you to deliver a favorable report on this bill. Thank you.
All right, good afternoon. My name is Cortland Merkel. I'm a staff attorney at Maryland Volunteer Lawyer Service. I work directly with low-income clients who are facing foreclosure and tax sale issues. As it is currently written, House Bill 59 would bring important and necessary reform to tax sale in Maryland. The bill will raise the tax sale threshold to $1,000 for homeowners across the state. Currently, some thresholds are as low as $250. This bill will prevent properties from being sold if the unpaid taxes and citations total less than $1,000. At MVLS, we've collected Baltimore City data at our joint tax sale clinics with the Pro Bono Resource Center about who is most affected by tax sale. At these clinics, 72% of the clients have a household income of $30,000 or less per year. One such client is Miss T, who, like many, is on a fixed income. Miss T is trying to pay her $900 tax bill this year, but the sad reality is that she could lose her home in tax sale. By raising the threshold, this bill will help keep low-income Marylanders like Miss T in her home. In addition, House Bill 59 will also cap interest rates, preventing small bills from becoming huge, unimaginable debts. This will help more people redeem their homes and keep them from losing everything. MVLS strongly supports the current version of House Bill 59 because it sets a fair tax sale threshold for the entire state and limits the interest rates on redeeming homes. So we ask for a favorable report. Thank you.
Good afternoon, Chair, Vice Chair, and members of the Ways and Means Committee. My name is Claudia Wilson-Randall. I'm the Executive Director of the Community Development Network of Maryland. We've been long part of the tax sale prevention work, and we will continue to work to protect both people and places for the harms of tax sale. As my colleagues have talked about, the harm that comes to people across Maryland, the tax sale process harms both people and place. And I want to stress the context of this work, which is Maryland is nearly 130,000 affordable housing units behind. So what we need to do in this state is to keep low-income homeowners in the houses that they're in, because once home ownership is lost, the cost is astronomical to the state of Maryland and to local governments. And I really want to stress that here today. The cost of older adults in homelessness is, we can't easily put those folks, there's no place for them to go in the market right now, none. So we must put our resources towards programs like House Bill 59 that help more lower-income homeowners maintain homeownership. So I just want to applaud DHCD and SDET for the work they've done to help keep people in their homes. And I also want to mention that the harm that comes to places after tax sale. Tax sale helps and benefits private investors. It does not help local governments. The help that is given to local governments is in the short term. The long-term cost is a vacant property that flows quickly into disinvested areas. So I just want to be clear about that, and I want to encourage you for a favorable report for House Bill 59. Thank you so much.
Good afternoon. Thank you for the opportunity to testify. My name is Shana Roth-Gormley. I'm a staff attorney at Community Law Center. We're a legal services provider to nonprofits and community organizations throughout Maryland. And we've seen the negative impacts of the current tax sale system and the ways that it contributes to property vacancy and abandonment. And that's what I want to really focus on today. HB 59 would help prevent the loss of family homes in tax sale. It would prevent these homes from becoming vacant, which we know does happen to properties as a result of tax sale. The bill would allow municipalities to withhold properties from tax sale for redevelopment purposes. It would decrease the amount of time that the tax sale purchasers have to bring a foreclosure case for abandoned properties, for specifically where the minimum bid is less than the lien amount. The benefit here is that if the purchaser doesn't bring the foreclosure case within a certain amount of time, the lien certificate goes back to the municipality, which can foreclose. This is an important protection to extend statewide. It already exists in Baltimore City because now communities have less time to wait for action on vacant properties in their neighborhoods. HB 59 would also help protect churches and other houses of worship from losing their properties if the only liens are water bills. From Community Law Center's experience, this has made a difference for houses of worship in Baltimore. Since this went into effect a few years ago, we're getting fewer calls from houses of worship with properties in tax sale. So these faith institutions now have more time to address these issues with delinquent bills without the ticking clock and without the labyrinthine complexity of the tax sale process. I urge you to give a favorable report on HB 59 as it's written and not amend it. We know that limiting certain provisions of the bill to only owner occupants and amending it in that way would exclude tenants, families, and heirs from these protections and not address some of those underlying issues that the bill was written for. Thank you very much.
Okay. Are there any questions? Okay, see done. Thank you all very much. Councilwoman Ramos. David Wheaton, Dan Ellis, John Kern, Meredith Gerard, I didn't see you back there, Councilwoman. I apologize.
Oh, you're fine.
All right, do you want to start?
Sure.
Okay.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. My name is Odette Ramos. I am the City Councilwoman for Baltimore City's 14th District. Prior to becoming a councilwoman, I was before you many times talking about tax sale and working hard to prevent people from losing their homes or from succumbing to this predatory practice of tax sale. I wanted to just take my time to answer a couple of questions. In terms of, expanding our protections that we have in Baltimore to the rest of the city relative to water bills, this committee had passed several pieces of legislation over the years to allow for other ways to collect by adding affordability plans, payment plans, and other ways so that there are other ways to collect and not just through the tax sale, which again is predatory. We don't need to have people making a choice between eating medications and paying their taxes or water. So this body has done a lot of work on this issue in that regard. Also, there are jurisdictions that, have said that they don't want to use shutoffs, but you can use affordability plans and payment plans. The other piece I just want to mention is that, this is an important thing for the governor and the DHCD to be doing because as one of my colleagues said in the last panel, this is it has a lot to do with how we end up with either vacant properties or people who end up homeless. And that's not something that we want to do, particularly for our older adults. I'm happy to answer any questions. Thank you, Madam Chair.
Thank you, Madam Chair and members of the committee. My name is Meredith Gerard. I'm Executive Director at Shore Legal Access. We are based on the Eastern Shore, where we provide free legal services to folks who otherwise could not afford an attorney. And we provide legal representation for folks who are facing tax foreclosure. And so much of the time, these are relatively small amounts of money that folks owe. And by the time it gets into tax foreclosure, it is a lump sum that they're just simply unable to pay. One of our recent clients just a few months ago was an older woman in her 80s. Her spouse had passed away. She'd lived in her home for 50 years, and she was facing tax foreclosure because she couldn't come up with the $1,800 that it was required to get it out of tax foreclosure. So she is exactly the sort of person who would benefit from this comprehensive reform. We included in our written testimony a rundown of some of the Eastern Shore counties and the thresholds for tax sale in our community. And House Bill 59 would raise that threshold significantly, along with the other comprehensive reforms, therefore giving people with relatively small amounts of taxes a greater ability to get their situation back on track and get their homes out of tax foreclosure. I really appreciate you listening to us today, and I urge your favorable support for this bill with no amendments.
Good afternoon. Thank you, Madam Chair. My name is Dan Ellis. I am the CEO of Neighborhood Housing Services of Baltimore. And at NHS of Baltimore, we believe that economic and social justice is a right for all people and communities, and we work to do that. I've been working on tax sale bills, legislation, and system change since 2012, and have been before you many times to talk about tax sale, including many of the ones that we instituted in Baltimore City that this bill proposes expanding around the rest of the state. These protections are really critical help in Baltimore City, and we believe will help many people around the rest of the state. And we applaud the Secretary of DHCD for leading the effort to implement this bill. The impact is that residents can remain in their homes. And that's really critical, as some others have testified, because it saves money to the local jurisdiction from not having to provide the social services that are often needed when someone is displaced. The bill does a number of things. It raises the threshold to $1,000 for owner-occupied property. It lengthens the time before foreclosure can occur. It caps the interest rate, and it also provides some protection for renters, which is really a critical element because losing your home with 30 days notice is often difficult for people to secure additional housing, especially in an environment with significant housing shortage. We also highlight the issue of water bills, as has been mentioned by some of my colleagues. We strongly support the bill that it currently removes all water bills from tax sale, and we fully support this. We worked with Baltimore City and with this committee in 2019 to provide these protections in Baltimore City, and we want to ensure that they remain in place. We also appreciate the payment plan option that is created by this plan. We thank the committee for their consideration of this bill and for their leadership over the years in providing protection to low-income citizens of Maryland. Thank you.
Good afternoon, Chair and members of the committee. My name is David Wheaton, and I'm an attorney with the Legal Defense Fund. Founded in 1940 by Thurgood Marshall, LDF is the nation's oldest civil rights law organization. And I'm here today to testify in support of Maryland House Bill 59 as currently written, which would help keep Marylanders in their home by preventing the government from selling their property due to unpaid water bills. This legislation also provides a more equitable process for renters whose homes are going through the tax sale process. This legislation gives expanded notice when tax sale proceedings are happening at their residence, which will give renters 3 months notice to move. Current Maryland law only gives a renter 30 days notice for a renter to move when their residence is going through the tax sale process. This legislation has the potential to help thousands of Black Maryland residents as Black homeowners disproportionately lose their homes to tax sale foreclosure, and delinquent property tax enforcement systems unfortunately unfairly burden communities of color. In 2019, the Maryland General Assembly unanimously voted to protect all households and places of worship in Baltimore City from tax sales due to unpaid water bills. House Bill 59 would expand these protections to include the rest of Maryland. Baltimore's experience shows the impact House Bill 59 could have for Black Marylanders. Before 2019, thousands of Baltimore residents regularly lost their homes due to unpaid water bills through the tax sale process. This practice often displaced elderly Black women on fixed incomes and led to overall decrease in home ownership in Baltimore. Data from the Tax Sale Prevention Project shed some light on the demographics of Baltimore homeowners. In 2016, 80% of the clients with tax sale issues were Black, 73% in 2017 were Black, with a majority of household income under $30,000. And so HB 59 is an important step to curtailing tax sale foreclosure throughout the state of Maryland and gives added protections to homeowners and renters. This legislation ensures that water bills alone are not enough for someone to lose their home, and the legislation also creates a better notice requirement for renters whose homes are going through the tax sale process. We ask for a favorable report out of committee. Thank you.
Good afternoon, Chair, committee members. My name is John Kern. I work with the SOS Fund. We're a housing equity nonprofit in Baltimore City, and we're really downstream in the tax sale process. So we work with homeowners that are deep in the throes of the redemption process. And just to point out a couple provisions that we love, this heirs property provision, I want to just say, is so important. So the folks living in heirs properties are the most vulnerable to tax sale in the first place because they don't qualify for the programs that would keep them out. So that we applaud for that provision. The second, having to pay the subsequent year's tax bill is super onerous. So we raise money to help folks redeem to the tax sale. And a lot of folks will pay their tax bills in the spring with their tax returns. So this is the time you'll see a lot of redemption happening. If you tack on that next bill, you know, usually they pay that in the following year. So having to pay that up front is awful for them. The last about the water bills, you know, we have an epidemic of deferred maintenance across a lot of our jurisdictions. And so even if folks are up on their property taxes, all the other bills, you may see a burst pipe and it causes their bill to skyrocket. And suddenly they have a huge high water bill, and filing for the programs to do rate adjustments can be tricky for them. So we also applaud taking the water bills out. And in terms of the jurisdictions and the collections question, which has come up, Baltimore City is going to do a rate hike, and a lot of the residents were asking about collections around. They did a letter writing campaign to commercial properties around the city and collected $56 million just by reaching out and asking them to pay their water bills. You can do payment plans with them, and you can revoke their rental licenses as a threat if they don't pay their water bills. So there is myriad options for jurisdictions to collect water bills without using tax sale. So I encourage a favorable report on HB 59, and thank you so much to SDAP for all their work on this bill.
Thank you. Any questions from the committee? Delegate Miracu North.
Thank you, Madam Chair, and thank you for, well, actually, this is prior, but thank you to the Secretary, and thank you all for your advocacy. I remember this issue like it was yesterday, even though it was last year, so I'm hearing you loud and clear. The lady, I forgot, I got you, and I apologize, with the glasses. You mentioned the example of a tax burden of $1,800. Is that an 1800 store? I think, was that the story you mentioned?
I'm sorry,
there was an example you mentioned about women owing 1,800.
Mm-hmm.
Okay, the bill as written says for non-owner occupied residential property, the sale is withheld for less than $750, and then for owner occupied less than $1,000. So the story that you mentioned, would that apply to this bill, or am I reading the bill incorrectly? I want to make sure I get your story linked up with the bill.
Sure. So just to clarify, her bill started at way less than $1,800.
Got it. Okay.
It skyrocketed and piled on and snowballed over time.
Okay.
So she was dealing with an estate because her spouse had passed away. There was a lot of debt that had to be paid, and as a result, she got behind on the taxes on the house. So it started out as a much lower amount. That was less than $1,000,
Okay.
and she would have benefited.
Awesome. Thank you so much.
Any other questions? Delegate Young.
Thank you, Madam Chair. This is for the councilwoman, since she's here. She represents part of my district, too.
Yes.
I can't remember if this was your bill in Baltimore City. Can you remind me of that? And then secondly, there was a question earlier just about the impact in Baltimore. So can you just speak to what that was or how that's been?
Sure. The work that we've done in Baltimore is pretty broad. I mean, we needed permission from the General Assembly to do a lot of that work. I have put in a bill in the last term to create payment plans in Baltimore City, both for people to pay every month ahead, you know, so that they're not paying 2 times a year, as as well as for payment plans. The city is still in the process of implementing my bill, and so we're working on getting that up and online as quickly as possible so that the people who we've pulled out of tax sale and anybody else who needs it can go into a payment plan. We're also funding groups like SOS Fund to work with one-on-one with our residents to get them into the payment plans, but also to be eligible for the homeowner's property tax credit. And I'm sure the committee is very familiar with the homeowner's property tax credit, and it lowers the amount that somebody would have to pay, and then Maryland, the state, pays the city. And in terms of water bills, we've created a payment plan for that. So there's a lot of work that's been done, and there's still more to go in order to make sure that we're doing this right. It is a major value of our city, as you know, Delegate, that we do not want to have people lose their homes because they cannot pay the water bill or their taxes. That is something that has been clear for this administration and also for the work that the City Council has done. So there's still some more work to do relative to collections, and I think that our work can be a model for the rest of what's happening, what could happen in the rest of the state. But we are making strides. Thank you.
Okay, seeing no other questions, thank you very much.
Thank you.
Next, Alan Lang, George Aguilar, and then Kevin Canale is favorable with amendment, if you could come up as well, if he's in here. Kevin.
Thank you, Chairwoman and committee members. My name is Jorge Aguilar, and I am the Southern Region Director for Food and Water Watch. I'm here on behalf of my organization and our 44,000 supporters in Maryland to urge you to pass HB 59 to prevent the potential eviction and foreclosure of Maryland residents for unpaid water bills. That is the piece we are really supporting in this, as well as the other reforms. We have been really glad to work with the administration on this and thank them for all of the tax sale reforms they've included in this bill. So I'm kind of reiterating what other folks have said. We know these tax sales for water bills don't just impact the owners of a property, but also renters is a big issue for us because they live in these properties, and today more than 750,000 renters in Maryland could face eviction. And so that's why we really want the clean language that the administration has introduced. That's why it's so important to us. And we know that Black households are twice as likely to rent in Maryland as white households. So this is another reason to keep the language as it is in the bill. I'll add again that municipalities have other options for collections on debt related to water bills as part of the tax lien process. And cities like Baltimore have implemented other methods like what is mentioned before, the pay promise system, to put residents who've fallen behind on a payment plan. So what we are asking for today is that the most extreme and cruel option of taking someone's property, which comes right now with a huge tax incentives for collection agencies to use, we ask that that very cruel option be removed as a way of getting people to pay their water bill. There are other options, but water is just on a different level. And this committee should recognize that there are other ways to collect that exist. Please pass HB 59.
Madam Chair, fellow members, my name is Alan Lang from Harwood, Maryland, and I support the bill. Everyone before me has said what I would have said, so I yield the time back to the committee.
Good afternoon, Madam Chair and members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of the bill with an amendment. Obviously, there's a lot of conversation. It's a tough bill. I think that this committee understands MACO has been in the room and I think very productive in terms of reforming the tax sale process. We've made a lot of progress over the years, including the homeowner protection program. We'd love to have more money there. But we feel like this bill jeopardizes enterprise funds. We would ask for an amendment to limit the water and sewer provision to only owner-occupied properties as the committee amended the bill last year. Again, this is not that counties don't want to take anyone to tax sale. It's a shall in state law. It's not a may. This is the only option that we have. The state forces counties to take these liens to tax sale. And again, we don't want to jeopardize enterprise funds. We feel like we can make progress with this bill by protecting the most vulnerable people in owner-occupied properties. But if you were to extend it to all residential properties, the fiscal note increases tremendously. As you all know, the budget situation is rough. There are a lot of proposals to shift costs onto county governments. We're trying to fund the blueprint. We're trying to address affordable housing. We're trying to do a lot of things every single day. We only have property taxes to fund those services. We have no flexibility. So we're just asking that you please think about these provisions in the fiscal note associated with them. We want to make progress, but limiting it to only owner-occupied, I think, moves the ball forward significantly without risking a significant unfunded mandate for county governments. And with that, we'd ask for a favorable report with that amendment.
Thank you. Any questions? Okay, thank you very much. Moving to the unfavorables, Justin Fiore, Frank Boston, Ari Plout, Heidi Kenny, and then we do have two people that should be with us virtually.
Good morning, Madam Chair, committee members. Justin Fiore here on behalf of the Maryland Municipal League in respectful opposition to HB 59 as it's been introduced. We have really one main concern left that we're working with the advocates, both secretaries on, and that's related to not being able to take a property to tax sale for water or sewer only. I think as my colleague from MACO mentioned, these are enterprise funds, so we're dealing with this tough balance between protecting homeowners, protecting ratepayers, and protecting local water systems. So we're working on that, and we would respectfully request an unfavorable report as introduced or change that provision.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Ari Plout, here in opposition to House Bill 59. I'm here on behalf of the Kenny Law Group and the Maryland Tax Sale Participants Association. Mr. Boston is on the other side of the street. I'm here just representing, we didn't need both of us to be here. Just wanted to raise a couple points on why we oppose this bill. We see proposals to reform tax sale system every year. For example, 2022, we passed, your committee passed House Bill 1196. In 2023, there are 3 bills that passed, which was mentioned before, the Homeowner Protection Plan, House Bill 236. House Bill 235 was another bill that provided an extension on the timeline of when foreclosure proceedings can start, which also there's a provision in this bill which does another extension. So you just passed a bill a couple years ago which provided an extension, and then 2 years later this bill proposes another extension. We believe the system is working fine. We're still willing to work with industry stakeholders. We're willing to work on protecting owner occupants. In fact, the water bill that has been mentioned many times, we supported the bill last year that would have allowed water bills to be withheld in tax sale if it was owner occupied, and it passed this committee. And this year the bill removes water bill, removes statewide water bill from tax sale. And we just overall, we believe that this bill will disincentivize our clients to invest in the cities, and it makes it harder for the collectors to be able to collect and our clients to rehab properties. And with that, I'll turn it over to Ms. Kenny and respectfully oppose this bill. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Heidi Kenny. I'm an attorney who has done tax sale. I've continuously testified before this committee on several bills. There were a couple things I just wanted to point out in regards to testimony I heard earlier that I succinctly wanted to answer Delegate Buckles' question about the impact of these reforms. And I think it's $1 million question that can probably be answered by a multi-million-dollar answer, and that's to find out exactly what is Baltimore City's water bill delinquency since these bills have been enacted. I think it's a huge question to ask, like, how much money is sitting out there that there's not been collected as a result of these continued reforms. Statistically, I've been a foreclosure and collection attorney for over 20 years, and without some type of incentive or threat pressing on people to pay. It just doesn't happen. In fact, these reforms have incentivized people not to pay their taxes because it does impact some reforms that there's no incentive. Like, what's going to happen? Really nothing. We've heard from the ombudsman and other of the advocates that testified earlier that these measures that they've already enacted are working to protect the vulnerable residents. So at this point, I would just propose that we table this bill so we can work out the suggested amendments that we did last year on this bill. And two other clarifying points is the residential also incorporates landlord-owned property, so that's not protecting vulnerable residents as the secretary described. Also losing their property in 30 days for tenants is not accurate. There's a notice provisions that are required in the tax sale statute that notice be given prior to submitting for judgment and also afterward. And the designation of homeowner occupied is not limited to what SDAT determines it to be. Attorneys look at the title report to see if an affidavit of homeowner occupancy is filed with that deed, and that is what determines it. Thank you for your time. I request opposing this bill.
Okay, thank you. Are there any questions? Yeah, Delegate Robertson.
Okay. Thank you, Madam Chair. I'm new, so they're still trying to figure who I am. No, thank you for raising. So since I am new to this, you said that there were amendments from last year. Am I correct?
Yes, this bill is the third year, I believe, we've seen this submitted. And last year we submitted amendments that actually were accepted from all parties involved that passed both House and Senate, but I think it was Baltimore City delegation at the end that.
Yeah, because it was, removed, so Baltimore City opposed it, and it protected water bills. If it was owner occupants would have been protected, but water bills that went into tax sale that were not made it statewide. In Baltimore City, protected all residential properties. And the amendment that we propose would have protected just the owner occupants.
Okay, understood. I'll leave it there. Thank you.
Happy to chat with you in the future.
Delegate Wells.
Thank you. Thank you, Madam Chair. So I guess I wanted to kind of walk through a little bit more the opposition, specifically, because I think the language is pretty clear in terms of like the narrow focus around water and sewer. But also I really have a strong concern around the prevention of blight. So there's obviously a whole list of things in which why we don't want people to be homeless and unhoused. But in my district, in the 40th district, 56% of all vacant homes in Baltimore City are in the 40th district. So I am very interested in understanding what are some solutions to help us prevent further blight? And specifically, we know that where there is blight, it's harder to bring in development. It's harder to bring in redevelopment. So can you help me understand in more detail your opposition to even just this being tailored towards water and sewer, and I believe it said $1,000.
Right.
So can you just help break that down for me?
Sure. What I see is two separate issues. One is people who are paying or having difficulty paying versus blight properties that have not been paid and years of property taxes not being paid.
Let me just interject for 1 second. I'm specifically talking about avoiding future blight.
Okay.
That's what I'm speaking to.
Okay.
Because I know there's nuance to it, but specifically the threat of more blight because of tax liens being more aggressive or
So I look at it as a theory that the more you prolong people from paying, the more they end up owing. So the longer you take to tell people, okay, you have now 10 months, 12 months before you pay, stuff continues to accrue during that period of time. So it's not taking that one incident and saying, okay, this is what you owe, it stops right here. There's no stay. The water bill continues to add on as time goes forward. And what's interesting to me is all these reforms to stop tax sale and all of this thing, the longer you prolong people to force the issue to pay, the more people you end up losing. I've done this for 25 years. I understand that When people don't pay their property taxes one year, they're not getting it to the next year. It adds on and adds on. So the more you prolong people and forcing them to pay, the more they end up owing, and arguably the more blight you will have.
Okay, so then this is a yes or no question. So you don't believe counties and cities using policies around payment plans and payment arrangements, you don't believe that those are effective whatsoever?
No, the payment plans can be effective if you have people willing to pay.
Okay.
But if you get them behind the 8 ball and don't incentivize them to pay and pay quickly, the worse it gets.
And you believe tax sale is the only way to get people to pay effectively?
I believe that that is a mechanism that, with the threat of a losing of your property, incentivizes people to get it resolved faster.
All right, thank you.
And Delegate Roberson, I know did not have the benefit of this, but I just wanted to clear something up. The city delegation did not take this up last year, and this is because you will probably see there are differences of opinions on this issue. So we can talk about that offline, but they did not take this issue up as a delegation last year. Okay, any further, well, do we have folks here virtually? Okay, we'll bring them up. Thank you all. So we have 2 more unfavorables, and they're here virtually.
Thank you.
Thank you.
Yeah.
Can you hear me?
Yep, but we cannot see you.
Okay. I'm having a video issue. Can I proceed just on audio?
We'd like to see you. Can you work on that while we see if our other person is here? Adam
Sure.
Shipritz?
Let me try to get that working.
Okay, Adam Shipritz is not here. Michael Eskenazi, if you could get your video working. Okay, there you go. There you go. Thank you. Oh, wait, you're on mute now.
Is
There you
that
go.
working?
Yes, perfect. Thank you. For 2 minutes, go ahead, please.
Okay. Madam Chair, members of the committee, thank you for the opportunity. I'm Mike Eskenazi. I've lived and worked in Baltimore City for over 10 years, and I am with the Maryland Tax Participants Association. We strongly oppose HB 59. Tax sale is an essential revenue collection tool. It has been reformed many times to protect vulnerable property owners, and each new reform risks unintended consequences. Recent reforms include lowering interest rates, extending foreclosure timelines, capping attorney's fees, and removing nearly all Baltimore City owner-occupants from tax sale for 4 years running. In Baltimore City, the vast majority of properties sold at tax sale are now investor-owned. The threat of tax sale is what gets delinquent investors to pay, such that 35% of city property taxes are collected after delinquent tax sale notices are sent out. Property taxes account for more than half of general fund revenue, and losing this funding would put city residents at great risk of losing essential city programs and services. With owner occupants now protected, shouldn't investors, landlords, and derelict property owners be expected to pay their property taxes and water bills? According to previous testimony from DPW, delinquent water collections dropped significantly in Baltimore City following the removal of water bills from tax sale in 2019. And now, according to the Baltimore Brew, the city is proposing the highest water rate increase in a decade, 30% from now to mid-2026. This is not a coincidence. Meanwhile, the burden of this huge rate increase will fall on the poor and middle-income residents who actually pay their water bills. In closing, tax sale has been fixed and fixed repeatedly. Please don't sacrifice the essential programs and services that depend on tax revenue or the solvency of the water department in pursuit of endless tax sale reform. We've reached diminishing returns, and we are now doing more harm than good. Thank you.
Thank you. Any questions? Okay, seeing none. Thank you, sir, very much.
Thank you.
That concludes the hearing on House Bill 59. Calling House Bill 75. Director DeMarinis.
Thank you, Madam Chair. And thank you for introducing my last of my departmental bills. Jared DeMarinis, State Administrator of Elections, for the record. House Bill 75. The proposed legislation brings the conduct of a special election. By the way, this is different than all the other special election bills that you're going to talk about. This is just about the administration of a special election, and whether a county has it, it does not affect you or your special or any of those proposed legislations here. That's other policies. I just wanted to make sure that's clear. So this brings the conduct of special elections more in line with state laws and administrative necessities for conducting special elections, especially an election vote by mail, because that is the cheaper of the two options and more flexibility and has the greatest participation rate if they do a vote by mail. Basically, these elections, special elections, are no longer county specific, so the state board is now involved. And we are involved not just with oversight, but also the administration of these elections. It requires, 90 days to conduct an election and still meet all the requirements, most notably for military and overseas voters getting their ballot delivery 45 days before the elections. So by having it at the 90-day mark and allowing us, by making that a special election has to be 90 days, we make sure that we're going to getting out the ballots in a timely manner. Additionally, if a voter then subsequently misplaces, spoils, or destroys a ballot, or just needs to request a new one, there's still ample time for us to mail them out a new ballot so that they have time then to put it in the drop box. One of the bigger changes in this bill here is there is enabling legislation for the counties to eliminate or to just not have a special primary election in certain cases. This would be a cost savings for the county, and it will allow vacancies to be filled faster and can significantly reduce the workload for local election officials. This allows flexibility for each jurisdiction to fill the vacancy in a manner that best represents the needs for the citizens. So, in a sense, by having 90 days for an election, vacancies would not be filled for at least 180 days, maybe longer. We've just gone right to special generals in the past. Most notably, I can think of is the congressional race when Al Wynn had resigned, and we went directly to a special general election for that for that election there. So there's cost benefits for this and allows the vacancies and the voters to be represented at faster if the county so chooses. It's enabling legislation, so it allows the counties to make that decision on their own there. And then finally, the bill authorizes that the state administrator have oversight over special elections, just ensuring that they be conducted in a manner consistent with state laws and regulations if there's conflicts with any county charters or local laws. This basically eliminates any potential conflicts while maintaining the integrity of Maryland's electoral processes. This bill also, they're not here right now, but they've submitted written testimony. This has the support of Mayo, which is the local directors, so that they're in support of this as well. And I'm happy to answer any questions, and I look forward to a favorable report. Thank you.
Thank you. Are there any questions? Okay, seeing none, thank you.
Thank you.
We do have Kevin Canali in favor.
Thank you, Madam Chair and members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of House Bill 75. This bill, as Mr. DeMarinis pointed out, it does empower counties, charter counties, to decide how special elections are held, whether or not to include a primary or proceed directly to a general election. I think that's super beneficial in a spot where you may not have very much competition, and it doesn't really make a ton of sense to have a primary election. It does also update, a lot of the processes to modernize the voting process, requiring ballots to be mailed earlier, allowing for secure ballot drop boxes, and this just balances efficiency, accessibility, and election integrity. So a lot of flexibility in the bill. We feel like this does promote fair, open, and efficient elections, and this is the right way to go, especially when we have a tricky situation where you could decide that you need a primary or you don't, and in a lot of cases, it just makes more sense to proceed to a special election. There is a fiscal savings there as well, and of course, that benefits our residents. So with all of that, we support the bill, and we'd ask for a favorable report.
Thank you. Are there any questions? Okay, thank you very much. We have one unfavorable, Alan Lang.
Madam Chair, members of the committee, I'm Alan Lang from Harwood, Maryland. Most of my testimony consisted of questions, which the two gentlemen before me have answered. I guess the only exception I would have less is the elimination of the specimen ballot. I would like to change from to favorable with an amendment that the bill says the specimen ballot would not be run or not be used, and that I think that you should reconsider that. Thank you.
Thank you. Any questions? Okay, seeing none, thank you very much. That concludes the hearing on House Bill 75. I should mention House Bill 67, 91, 115, and 285 are being rescheduled at the request of the sponsor, who is unavailable today. House Bill 201, Madam Vice Chair.
Good afternoon, colleagues. I am Delegate Janelle Wilkins, and I'm pleased to present House Bill 201, Election Law Absentee Ballot Application, sending to eligible voters before primary elections. This bill extends our current practice of local boards of elections sending the absentee ballot application to each eligible voter 60 days before each statewide primary. We did conduct the election in this manner with the absentee ballot application sent in the 2022 primary and the 2024 primary, and this bill would extend that practice. I urge a favorable report on House Bill 201.
Okay, any questions? Okay, thank you very much. That concludes the hearing on House Bill 201. I do not see her. Is Delegate Foley here? Oh, there, I did not see you. Come on up. House Bill 174, we'll start with.
Thank you, Madam Chair. And I apologize in advance. I have a little bit of a frog in my throat, but I think I can get through this. Okay, so House Bill 174, General Assembly Special Election to fill a vacancy in office. Thank you, Chair Atterbury, Vice Chair Wilkins, and members of the Ways and Means Committee. For the record, I'm Delegate Linda Foley, and I'm presenting HB 174, which allows Marylanders to vote on a constitutional amendment changing the way legislative vacancies occurring during the four-year term of office are filled. So this bill is not new to you. You've heard it before, but I'm just going to update you a little bit on it. Currently, as you know, the County Central Committee of the departing legislator's political party recommends candidates to the governor, who then appoints a nominee to fulfill the remainder of a departing delegate's or senator's term, whether it be 6 months, 2 years, or in some cases a near complete 4-year term. HB 174 would inject more democracy and voter engagement in the vacancy filling process. The amendment, if approved by voters, would make the following change. If a vacancy occurs 55 days or more prior to the candidate filing deadline for the interim 2-year mark of a term, then the individual appointed by the governor would serve until and then subject to a special election held during the presidential election at the midterm of the 4-year legislative term. The special election would be held during the regular primary and general elections in the presidential year. Vacancy appointments made more than 2 years into a legislative term would not be subject to a special election. So this bill, as you know, is actually a compromise. The approach to hold special elections every year would require large expenditures by local election boards and would likely result in very low turnout elections that may not accurately reflect the will of the voters. HB 174 combines the efficiency and continuity of an appointment process with the democracy of voter input at least every 2 years during an election that's already scheduled. So, overall, 31 out of 50 states have procedures to fill legislative vacancies that include special elections in at least some circumstances. And only 9 states out of 50 have a process similar to Maryland where the governor appoints. Right now, in all, 23% of the 188-member Maryland General Assembly first acquired their seats through appointments, and for disclosure, including myself, and currently in the Senate, 8 members have been appointed since 2022. All these appointments were members of the House at the time of their appointment. In the House, 12 members have been appointed since 2022, with 2 seats still vacant. Let me add, I think there's also a vacant seat in the Senate. I lose track of these appointments because there's so many of them. All of these appointments to the House, of course, were from outside the legislature. The history of this bill, you may not know, goes back decades. The Maryland Constitution was amended to use appointments instead of special elections to fill vacancies in the 1930s. So prior to the 1930s, we did have special elections, and then in the 1930s, the Constitution was amended to go to appointments. Since then, about 250 legislators have been appointed rather than elected to their seats. A constitutional amendment requiring special elections for at least some vacancies was first introduced in 1996. And this version of the amendment that I'm proposing in HB 174 was first proposed in 2008 by Senator Rich Madaleno and then Senator Jamie Raskin from Montgomery County to advocate for more democracy and voter engagement. This is the 3rd year I put this bill before you. And last session, I note that it passed the Senate by a vote of 43-2. This year, there is again a groundswell of support in Maryland for some type of special election process to fill legislative vacancies. You will see testimony and support from all over the state. Pro-democracy groups urging a favorable report include Common Cause, Young Democrats, Shore Progressives, Women's Democratic Club of Montgomery County, Maryland PIRG, Sierra Club, Maryland Legislative Coalition, the League of Women Voters, and several members of various central committees. I join them and urge you to issue a favorable report on HB 174, and I'm happy to answer any questions. Thank you.
Thank you. Any questions? Okay, thank you. That concludes the hearing on House Bill 174. House Bill 87, and we have with us from the Environment and Transportation Committee, Delegates Allen, Longs, and Naraki. And if you have a question, please just find an empty seat, hop up, and let me know. Okay, whenever you're ready.
I'm back. Thank you. And if I can, Madam Chair, I'd like to call up Kevin Canali from MACO, who's on my panel. Thank you. Okay, again, good afternoon. Chair Atterbury, Vice Chair Wilkins, members of the Ways and Means Committee, thank you for having me here today to testify in favor of HB 87, short-term rentals and home amenity rentals, taxation, regulation, and crimes. For the record, I'm Delegate Linda Foley from District 15. This bill provides updated safety and tax regulations to short-term rentals to protect consumers, reduce unnecessary risk, and ensure Maryland counties receive their fair share and correct tax revenue from short-term rentals. The reason I decided to bring this bill before you arose last summer from an incident at a residential home in my district. The owners rented their property to a group for the sole purpose of holding a large-scale party. This party, and I kid you not, was titled Wet Dreams. It sold attendance tickets, add-ons including poolside private cabanas, had cars parked on the property's lawn and all along the street of the neighborhood, and even had shuttle buses from a local community center where more cars were parked. More than 1,000 people attended this party. I do want to note that this party, while held at a property registered with the Airbnb platform, was not an Airbnb rental at the time of the party. Regardless, Airbnb did the right thing by removing this owner from their registry of hosts, and I want to thank them for that. Very important that they did that. But there have been similar events in other parts of the state. 3 weeks after the Montgomery County party, a group in Prince George's County sold tickets to attend a pool event in a residential area where one individual was injured as a result of a shooting. In Brandywine, a large pool party at a rental property had somewhere between 600 to 800 attendees. There also were reports of large-scale parties along these same lines in Gaithersburg, Hyattsville, Mount Rainier, and Accokeek, and elsewhere throughout the state. And there are numerous reports of similar events around the country. While the activities at these large-scale events in residential areas are already illegal in many jurisdictions, the proliferation of these kinds of parties and events raise two concerns which this bill addresses. The first and foremost of those is the matter of safety. More and more homeowners convert private residences and private amenities, such as swimming pools, into short-term rental units or venues that are rented to the public. It's important to make sure that these rentals provide at least a minimum level of safety measures for the public that's using them. The members of the public who avail themselves of these rentals have an expectation that they will be safe while occupying the venue or enjoying the amenity. As mentioned, some of these rentals involve pools or other amenities, but still lack safety guidelines. So this bill would subject short-term rentals to the same safety regulations as hotels of similar size, including those regulations that apply to pools. This doesn't mean that every short-term rental would need to have sprinklers or that every private pool rented out for events would need a lifeguard. For example, any short-term rental pool under 2,500 square feet would only require signage indicating that there is no lifeguard on duty. If the pool were larger than 2,500 square feet, which believe me is a big pool, I swim, that's a big pool, then one lifeguard would be required for every 50 bathers. Not many, if any, backyard pools fit that criteria. Beyond pools, the bill also aligns short-term rentals with other basic hotel safety requirements such as smoke detectors or carbon monoxide detectors and signage. These measures have been proved necessary. In 2022, for example, a Maryland family occupying a short-term rental on Long Island tragically lost 2 daughters in a fire that could have been prevented. The rental home had 29 code violations and faulty fire alarms. This bill also centralizes the collection of short-term rental taxes to ensure consistency and fairness for both counties and the industry. A uniform process simplifies compliance for platforms, reduces administrative burdens for counties and short-term rental platforms alike. By streamlining collections through the Comptroller's Office, this approach creates transparency and accountability in the tax process, benefiting all stakeholders. Now, we know that the fiscal note is an issue, and we're working with the Comptroller's Office to mitigate the fiscal impact. One option is to phase in the cost of system upgrades over several fiscal years, allowing the comptroller to align expenses with revenue growth from central collections. Additionally, we're exploring how the new tax system can alleviate administrative pressures by streamlining collections and reducing redundancy for local governments, creating more efficient and cost-effective processes overall. And additionally, we could dedicate a small percentage of new revenues, which the fiscal note also notes are there, generated by the system to fund the necessary upgrades, which would help mitigate the fiscal note. We also have been working with Airbnb, Vibro, Swimply, and other interested parties on this bill, and I will be presenting some sponsor amendments as a result of these conversations. One amendment would remove the requirement that the intermediary, that would be Airbnb, Vibro, or Swimply, for example, to remove the requirement that they fund safety enhancements at short-term rentals. The amendments would also remove the reference to affordable housing in the bill. In conclusion, we are attempting to do something that everyone should agree with, protect consumers, and increase tax revenue for counties. For these reasons, I urge a favorable report on HB 87, and I'm happy to answer any questions.
Thank you, Madam Chair and members of the committee. Kevin Canale here in support of House Bill 87. We are aligned with the sponsor amendments, and we have some technical issues with the bill, but we strongly support this bill. As the sponsor pointed out, this bill is about two things. It's about revenue, and we're very happy that the industry, this is their proposal. They like the centralized process. They want more certainty across the board. We very much agree with them. I think you'll see other bills introduced this session that will reflect that priority for the industry. So we're very happy to hear that the industry has come forward and asked for this centralized approach. We think it benefits the state. The second part of this bill, more importantly, addresses public safety. You heard about the terrible incident in New York. It's not a matter of if, it's when. Something terrible is going to happen in a short-term rental unit. Someone is going to die, and people are going to be pointing fingers, wondering who was supposed to know about this stuff, who was supposed to keep these people safe. Right now, we have a hodgepodge of different laws across the state. There's no state regulation. Some counties know where these places are, some counties don't. Some counties search the internet and try to find listings so that they can identify where these properties are. When we talk about hotels, and we talk about short-term rentals, we're not talking about sprinkler systems, as the sponsor mentioned. We're talking about smoke detectors, carbon monoxide, and just telling people how to get out of the place in case there's a fire or another emergency. This is not stuff that should be very expensive, but these are things that are pretty obvious in terms of needed for public safety. Again, we're not trying to put anyone out. We're not trying to foreclose on anyone's ability to have a short-term rental, but there are issues that we need to address now before something terrible does happen. These are very, very minor changes. Someone should know that these places are safe. I think when you check into a hotel, you have a reasonable expectation that you will be safe, that someone has come along and made sure that that hotel is safe. I think that when you check into a short-term rental, again, I think people have a reasonable expectation. They booked it through a platform. They see the commercials on TV. They feel like these places should be safe. But I'm here to tell you right now, there is no one checking to make sure that they're safe. There's a self-certification in some cases for some of these platforms, but beyond that, there's no check. So we'd ask for a favorable report, and we're happy to work with the committee and the sponsor on amendments.
Okay, thank you. Questions? We'll start with Delegate Patterson.
Madam Chair, and thank you for the legislation, Delegate Foley, because in my county we had an issue with I will just say overcrowding, over occupancy. And so when you talk about safety provisions, it is imperative then in the bill that the counties establish how the authority for law enforcement officers, because in this case, people were at the dwelling, but the law enforcement was very limited in terms of what they were able to do. So this bill is needed, but clearly definitive regulations should be in place.
I agree with you that the party that occurred in my neighborhood, we had the same type of response. Law enforcement did respond, but there wasn't a lot that they could do. And we're hoping, again, that by putting in some safety requirements, minimal safety requirements, that there at least be some level of safety in short-term rentals. That's really what we're trying to do.
Okay.
Okay, Delegate Buckle.
Madam Chair, thank you, Delegate Foley. I just want to kind of walk through something, either you or Mr. Canali. So I'm reading, fiscal note says a short-term rental is defined in our existing law is the temporary use of a short-term rental unit to provide accommodation to transient guests for lodging purposes in exchange for consideration.
Right.
So that could be, a fairly small house. That could be a one-bedroom, tiny house somewhere, someone wants to rent it in Deep Creek Lake or Cumberland, Maryland, or Rockville. I want to come and spend a day. I'm going to tiny house. So that's short-term rental. But then you would make modifications to section 15302. I'm looking at page 3 of your bill that says, in addition to complying with the requirements of other subsections, a short-term rental unit shall be in compliance with the health and safety provisions that the county and municipal corporation impose on hotels or similar amenities located in the same jurisdiction. So that won't work. That just simply, you can't apply that to all short-term rentals because they could just be someone's tiny house. They could be someone's just a regular home that they rent out on the weekend. So I get what you're angling for, and I think everyone would be in support of that, to stop people renting these large, quote-unquote, party houses and using them as if they were, mini hotels. But I don't think we can impose the same requirements on someone who just owns a regular house or a tiny home, something like that, and say that they have to comply with all of the regulations you have for a hotel. Because if you do that, they won't be able to rent at all. They can't afford all the prohibitions that you have for hotels. So are you willing to sort of consider that? You had said below that section C, you don't want the platforms to have to fund those kinds of improvements because it would destroy the economic viability of these types of transactions, I think.
Yeah, well, thank you for that question, Delegate. So if you look at the regulations with respect to hotels, and this is also true with amenities like swimming pools, it's based on size, okay? So if it's a small, tiny house, the requirements are minimal. They would consist of, smoke detector, a carbon monoxide detector, and some signage about how to get out. That's my understanding of what it would be. Kevin, do you want to add to that?
And I think I respect everything you said, Delia, and I agree with you. I don't think we should expect anyone to turn their one-bedroom home into Marriott in terms of safety standards, right? But I think what we're talking about here, and happy to clarify, are smoke detectors, carbon monoxide detectors, and a plan of egress in case of a fire or an emergency, right? So I think anything we can do to clarify that. I know that seeing hotel regulations may seem like that's the whole world, but that's certainly not the intent. And I think they are based on size, and that's why the drafter, I think.
Right, so that would seem to make sense. You can work on that language because somebody's going to litigate over that.
Absolutely.
And say, well, wait a minute, the hotel was 4 stories. I just have a 2,500 square foot home.
Sure, of course.
I can't do all of this kind of stuff. So if there's ways to tighten that language, I think it makes a lot of sense. Thank you.
Yeah, absolutely. Thank you.
Thank you.
Delegate Long.
Thank you, Madam Chair. Delegate, good to see you.
Hello, Delegate.
Committee mate,
it's good to
thank
see you in this committee.
So a quick question for you. Just, I'm not sure if I heard you reference this in your testimony. What are your responses, I guess, to the comptroller and referencing two components of her testimony about the enforcement language and the rental intermediary?
Take that. I'm going to ask Kevin to answer.
So I know that we are in active conversations with the comptroller. I think there were some issues with drafting, and happy to work through that. There's a cost component to this. When it comes to the enforcement, the comptroller works very well with county governments every single day. They collect local income taxes and they remit them to counties. They collect local admissions and amusement taxes and they remit those to the county. They also keep a fee to cover their expenses. So we are in conversations with the comptroller. We know that a new tax system is apparently on the way, but we want to mitigate any of those costs and any of the costs associated with enforcement, and I think we can do that. And we're happy to present language once we resolve those conversations to do just that.
Madam Chair, if I may, a brief follow-up. Do you believe that the fee the comptroller collects, which I am aware of, would that help to reduce some of the fiscal no concerns, or is that up to interpretation.
Absolutely, and again, it's an administrative fee for processing, but we have, in our conversations with the comptroller, we're willing to make sure that we can mitigate that fiscal note, and whether that is phasing it in or keeping a larger portion in the beginning to help mitigate those costs. But we also know that they're going to implement a new tax system, so I don't think this is going to be a multi-year issue. Anything we can do, though, we know the fiscal note is a problem, and the comptroller's been great in trying to mitigate those concerns and work with us.
Thank you, Madam Chair.
Delegate Hornberger.
Thank you, Madam Chair. Two questions. First, building on my colleague here, you can rent just about anything these days for any reason. You can rent someone's pool. You can rent a boat. You could live on the boat for a week or two or go on a vacation. And then also where I live, we have things like hunting cabins, for example, and the like. So how would this apply to those where it is a multi-day? They may or may not be spending the night there. The definitions section seemed a little broad to me. So how does one draw a line in the sand?
So I'm not sure I understand the question exactly. You're talking about?
Talk about multi-day rental.
Okay.
Where someone may or may not be spending the night.
So again, I think that it's absolutely imperative that any dwelling has a smoke detector, a carbon monoxide detector, and it tells people how to get out in the case of an emergency, regardless of whether that unit is occupied 1 or 5 or 10 nights. I think if something is listed on a platform for rental, we should make sure that we have minimal safety standards in place. I mean, that's the intent of the bill.
Okay, so I can rent a sailboat here in Annapolis.
So I would think that someone would have needed to inspect that, and you need to be registered in some capacity with DNR. So I would imagine that they did make sure the vessel was safe. I'm not an expert on boats, but I think that would be the case, that you'd have to register your vessel with DNR. But I'm happy to follow up with you.
And then my second question is more from a liability standpoint. I'm going to go out on a limb here and assume that county governments don't have the ability to inspect all of these.
Correct.
I mean, they can't even inspect apartments and other dwellings. So by bringing this tax in to the county, and then basically the county, which prior to this, they may have had no interaction with these properties or the people that rent them. Are they taking on any liability in the fact that there's no way that they can verify all these properties are compliant? Folks will continue to rent them, tax will be submitted. If the scenario that plays out that you just alluded, where someone dies or there's an accident, who's on the hook?
Well, I think what this bill is asking is for the platforms to verify that all of their rentals have this very basic intermediary, rudimentary safety equipment, right? And so I don't think this gets into inspections. And again, counties are not asking to go inspect these properties. Right now, again, the short-term rental companies typically don't want to disclose where the properties are, but I think the reason they want to work with the comptroller is because the comptroller does have abilities that counties don't have in terms of audit and things of that nature. I think that the industry would much rather work with one entity than 24 across the state. And so this whole idea about the centralized collection is an industry proposal. I do not believe there would be additional liability, but I'm happy to talk offline about that as well.
And Delegate, if I could add, I think, what we are in discussions with, or what we're contemplating, as opposed to having the platforms pay for it, is what the bill says, pay for these security measures or these safety measures. What we're actually looking at now is, a notification to the renter, to the owner, saying, you understand that you must provide this. Just like Airbnb responsibly, when the party occurred in my district, found out that the property was on the registry and didn't follow the rules with respect to Airbnb and large events, and they took them off of the registry. We would hope that there would be that kind of vigilance and policing, if you will, by the platforms themselves.
Okay, and then the last question, if I may. We're getting into a gray area here, whereas it's my home, and let's say I'm renting a cot or a place for a student to stay, or something along those lines. Maybe there's a complaint that's generated, maybe something went wrong. How does one, from a county government or from a private corporation, now have the ability to come inside my home?
This bill does not speak to that at all.
Okay. So how do you enforce the safety standards that you're describing?
Again, I think that the bill speaks to asking the platforms to advise and ensure that their hosts are, again, providing this very basic safety equipment. And I think it's up to the platforms, if you want to do business in the state, I think they should make sure that these rentals are safe. I mean, I think that's the bottom line here. I don't think we're asking for too much. Again, smoke detectors, carbon monoxide detection, and a plan to get out in case there's a fire. That's it.
Thank you.
You all keep mentioning smoke detectors, carbon monoxide, and sprinklers. Is that already, like, don't houses already have to have that?
Correct.
Yeah, it's already in the law with respect, Madam Chairman, it's already in the law with respect to hotels. That's what the law
But
talks
not private residences? Private residences?
In some counties, in some counties, I think that might be the law for private residences.
I think depending on building codes and when a dwelling was built, that plays into that. Any new construction, absolutely.
Right.
But again, we want to make sure that anything that is rented out and someone's going to come and stay and has that reasonable expectation of safety actually is safe. So
Okay.
complying with law in many circumstances.
Or they can conversely have a statement that says,
Correct.
this home does not have X, Y, and Z, but feel free to rent it.
I suppose. I mean, it's a little bit, yeah, sure.
Delegate Roberts.
Mike went off.
I don't think I touched it.
Thank you, Madam Chair. I just have two questions. The fee that would be imposed because of, the system from the comptroller, is there any approximation for how long it would take to pay for that? And after it's been paid for, does that fee go away? Because we get fees and then they tend not to go away.
So just to clarify, the fee, the administration fee would be against the revenue that the county would bring in, right? So typically, again, when the comptroller collects on our behalf, they keep an administrative fee, the cost of what they have to do, and then they remit it to the county. I think what we're talking about here is they would still keep that fee like they do with everything else, but if there is a way to mitigate the upfront costs, I think we'd be willing to talk to the comptroller about that. I think once the new tax system is in place and once those costs are mitigated, you would probably go back to that standard, very nominal fee that just the comptroller uses for processing other taxes and fees that get distributed to county government. So it's a very nominal fee, and it's on the county, not the resident.
Yeah. And Delegate, I'm sorry.
Then the county would pass that on to the owner, right?
So in this instance, I mean, this would be you book a short-term rental and you're paying a local tax, just like you would at a hotel.
Sure.
So I think the tax rate would be set, and then the business about the fee with the comptroller would be between the county and the comptroller. And again, it's a very nominal fee. I don't think it would be something that we'd pass on. It's just the cost of processing. So it's not like it's a pass-through where we could just pass that cost on. The tax rate would be set, and then the amount remitted back to the county, that's what we're talking about, and that's where they take a nominal fee, just as their cost of doing business, and that's a process that's well-known and goes back as long as we've done this.
And also, Delegate, if I could add, that the fiscal note notes that the real cost of this is a one-time cost for setting up the system. So once that money comes into the comptroller's office, then, the comptroller's fee could either go down or may go away.
Okay. And then the other question is, I'm not familiar with VRBO. Right, I'm not, right.
I can never
Verbo.
say that.
I'm not familiar with VRBO, but I am familiar with Airbnb. And I know that there are other short-term type of situations, like, for example, traveling nurses that may rent a place for 3 months. Would you still consider that as part of this new hotel tax that will be extended to that property as well? Are there only certain types?
So I think in the current law, it's 90 days or less, right? So
90 days or
yeah,
less,
so I think that's within the definition. We can clarify that for you, but certainly I don't think we'd be looking to target a longer term stay. Although I do think that all those places should also have smoke detectors and carbon monoxide, but that's not this bill.
Right, and I understand the smoke detectors and all of that stuff. I actually kind of like the chair's bill, the chair's suggestion with respect to that. But in terms of a little bit longer term, because, it's kind of not like a hotel type situation. So I was only speaking on the tax part of it.
Yeah, so I don't think that would apply. I think, again, we can get back to you on that, but it's defined in current law of what that actually means and how long you would need to stay to trigger. Currently, it would be a hotel tax, but then would also apply to these transactions as well. But I will follow up with you on that.
Okay, thank you.
Thank you.
Thank you, Madam Chair.
Thank you. Okay, no more questions. Thank you both very much.
Thank you.
Thank you.
We have several unfavorables: Cameron Kilberg, Jamie Gregory, Lisa May, and Ashley Bagwell. Come on down.
Do you want me to go? All right. Hi, sorry, a little coordination here. Jamie Gregory, I'm here representing Airbnb. Madam Chair and the committee, thank you for letting us testify. If I may, I'd like to take a minute and talk about how Airbnb is an economic lifeline for many hosts and an affordable travel option for guests. In a recent survey, 42% of hosts in Maryland said the money earned helped them stay in their home. 60% of hosts are female and earned about $13,000 in additional income. Approximately 800,000 people visited Maryland by staying with an Airbnb host, which resulted in Airbnb contributing $667 million to Maryland's GDP and collecting $210 million in total tax revenue. You heard some mention about the affordable housing references being taken away. I just want to point out that in Maryland, there are over 2 million dwelling units. Airbnb stays take place in less than 1% of those units. There's a real test case in New York City right now where Airbnb or short-term rentals have been limited. Airbnb listings have dropped 92%. Vacancy rates have remained unchanged. Rents are continuing to rise, meaning that housing affordability has not improved, even though short-term rentals have been restricted. You heard talk about the tax collection. We have been talking with the comptroller since over a year at putting together a centralized collection facility for all counties. We've been talking with the chairwoman and Chair Gazzoni. We're hoping to have a blueback bill by the end of the week. Chairman Gazzoni's staff is working on it. When finished, we're hoping that it'll be an Atterbury-Gazzoni bill. So we're hoping that the section of, to be honest, Delegate Foley's bill can be superseded by the chairwoman's bill. Finally, public safety. Airbnb takes it very seriously. There is a permanent ban on the site on parties and a prohibition on party houses. The use of reservation screening technology to block higher risk bookings, a 24/7 neighborhood support line, a dedicated portal for law enforcement to connect to get information on the property. And we've partnered with VRBO to identify and permanently remove properties from both our platforms that are party houses. We take the question of party houses very seriously. Specifically, the event that Delegate Foley mentioned, it was not an Airbnb property. There were many local regulations that could have been used: alcohol control laws, noise violations, capacity issues, parking hazards, fireworks restrictions are all regulated at the local level. So we would argue that an unfavorable report is needed.
Good afternoon, Chair Atterbury and members of the Ways and Means Committee. I'm Ashley Bagwell, here this afternoon on behalf of Swimply, respectfully in opposition to House Bill 87. Here with me this afternoon is Cameron Kilberg with Swimply. Before I turn it over to her, I just want to make 2 quick points. First, a lot of the testimony you've heard on this bill this afternoon, it was about and has been about short-term rentals, but it's important to remember that this bill impacts home amenity rentals as well. It's also important to remember that home amenity rentals, like Delegate Hornberger said, is more than just swimming pools. Swimply is starting to expand their platform to allow other spaces to be rented, but there are a number of other platforms like Sniff Spot, Peer Space, Gigster that also allow homeowners to rent out different parts of their homes or their properties for rental by the hour. I'd also like to just piggyback on the comments that Mr. Gregory made about Airbnb's policy with regard to large ticketed events. The events that have been mentioned today and perhaps that y'all have read about in the papers or have seen about in the newspapers were also not, it's my understanding they were not rented on any platform of any kind. In addition, Swimply also has a prohibition on large ticketed events. If if a user rents a property and has a ticketed event, Swimply will remove that user from their platform. In addition, if it's discovered that a homeowner had knowledge that their property was going to be used for a large ticketed event, that homeowner would be removed as a host from the Swimply platform as well. With that, Madam Chair, we would urge an unfavorable report, and I'll turn it over to Cameron Kilburg for some additional comments.
Thank you, Madam Chair, members. Thank you for allowing me to speak today on HB 87. As noted, my name is Cameron Kilburg, and I represent Swimply. We are an online marketplace for renting home amenities by the hour. This includes private swimming pools, sports courts, yards, and other amenities within the home. As Ashley mentioned, we have a no-ticketed event policy on our platform, as does Airbnb. While Delegate Foley noted the rationale for this bill is to protect communities from party homes and a variety of risks they raise, and I do believe she had good intentions. This bill does not solve her concerns, and it goes way beyond smoke detectors. This bill unfortunately opens Pandora's box of regulations and costs and leads to de facto statewide ban in all forms of home sharing. With the limited time I have, I'll do my best to explain. This bill not only turns any and all residential properties which are shared, which could be your traditional STRs or a home just being shared, to host a nonprofit or even a political event into public places, it also requires they abide by public safety and health code requirements for hotels. These are not minimal requirements. This is simply not feasible. First, by turning your property into public places, these properties may not willfully and without lawful purpose obstruct or hinder the free passage of another in a public place. This requires that these homes, which are open for private guest use, would need to allow any member of the public to enter. Second, the state and therefore the counties which apply state codes have a slew of health and safety codes which are not applicable to residential properties. It's not simply based on size either. They would not per se fix any of their safety concerns, health or safety concerns cited here today, nor would they stop these nuisance parties. By requiring any home which is shared and has a pool to be in line with these hotel regulations, they would be turning every such home into a public pool. These regulations go way beyond lifeguards. Most importantly, residential homes are constructed under a different building code, and thus their pools and homes do not meet the same construction standards as hotels. These are not minor changes, but even if they were, once a residential home would conduct such alterations, they would then be out of compliance with local residential building codes, thus creating a catch-22. I will wrap really quickly here. Obviously, this creates, in our view, just more headaches and solutions. It's going to increase costs for oversights for localities to ensure compliance, and it's not really fixing the true health or safety issues that have been raised. And so we simply oppose HB 87. Thank you so much.
Thank you, Madam Chair. Lisa May with Maryland Realtors. Our opposition to the bill is as it is introduced, though we certainly understand the circumstances that led to it. We are happy to work with all of the stakeholders here on amendments to make this a more narrowly focused bill. Thank you.
Loved the length of that testimony. Delegate Miracle North.
Thank you, Madam Chair. This question is for Mr. Gregory. You mentioned a statistic about females using Airbnb. 60%? You said this percentage of females doing Airbnb? You mentioned a statistic regarding females.
Oh, I'm sorry.
Yeah, it's okay.
Yes, in Maryland, the latest survey, 60% of Maryland hosts are female and earned about $13,000 in additional income.
Okay, and is it possible to get statistics on whether these females are head of their households?
I don't know.
Okay.
I'll find out.
Thank you.
Yeah.
Delegate Miller.
Thank you, Madam Chair. Are there any safety metrics that are required in these rentals that you have, like standards, any kind of safety standards that are required? I've seen when I rent that sometimes it is listed out, whether it has like a carbon monoxide detector or things like that or not.
I mean, I know Airbnb has, we're a little bit different because they're lodging, so some of the things you might list that you have, but, as a platform, we cannot dictate to the properties every piece, or safety equipment or railing or whatever it might be for stairs that would be required. However, if, we do have a feedback motion, so if a home gets a bad review, in the logarithm, you go down, so that's one piece. But if it is a true safety concern, something's written in, as a company on Swimply, I don't want to speak for Airbnb or VRBO or SniffSpot or anyone else, but we will take a look at that. If the property looks unsafe and we've had complaints, we can remove the property. But we don't inspect, we can't demand or require certain aspects for each property.
And to my chair's point, is there some kind of like release of liability or something like that anyone?
So we can't require homeowners to have guest sign releases. We do know some, on our side, we have hosts who ask guests to sign a release and acknowledge the property. We do not require that, nor can we give them such a release. We do have our own terms of service that you understand you're coming to use the property as is. It's your responsibility to review that property, make sure it's safe, and as a host, it's your responsibility to offer a safe property. But we don't, as a company, we cannot dictate what that is. It's just, you're making a contract together to look at that, the host and guest.
Okay. Is that different for Airbnb?
Let me get back to you on specifics. I don't want to speculate.
Okay, thank you.
Okay, seeing no further questions, thank you all very much. That concludes the hearing on House Bill 87. House Bill 253, Delegate Harris.
Great afternoon, Madam Chair, Vice Chair, members of the Ways and Means Committee. Name is Delegate Kevin M. Harris. I represent Legislative District 27A, which covers Charles and Prince George's counties. Thank you for the opportunity to present House Bill 253. Maryland is a state that prides itself on equal access for all residents, particularly when it comes to electing its officials into public office. Every citizen has the fundamental right to vote, yet pretrial detainees are presumed. Let me restart that sentence. Every citizen has the fundamental right to vote, yet pretrial detainees who are presumed innocent are often left unable to as a result of a significant barrier to casting their ballots. Many detainees are often left unable to vote due to logistical and systematic challenges of casting an absentee ballot. While in custody, whether it be barriers, tight deadlines, or confusion about voter eligibility. House Bill 253 will tackle this issue by ensuring eligible voters can exercise their basic rights regardless of their circumstances. Under the provision of law, the State Board of Elections or municipal boards of election must automatically mail absentee ballots to pretrial inmates without the detainees having to confront additional impediments to exercising their fundamental voting rights. Disenfranchising people before they are even found guilty of their accusation is damaging to society and set a dangerous precedent. This bill promotes equality and bolsters our democracy by ensuring that no voter is disenfranchised due to lack of uniform streamlining of voting access for these individuals across the state, regardless of their socioeconomic or interim incarceration status. Other states, such as Massachusetts and Nevada, have successfully implemented similar measures to improve access to mail voting by distributing voter information to eligible voters and providing voter assistance for requesting, completing, and returning forms and ballots. And Maryland has an opportunity to set an example by protecting the rights to vote for all eligible voters. I respectfully request a favorable vote by members on House Bill 253 to continue to uphold our democratic principles, and I'm happy to answer any questions you may have. Thank you for your time and considerations.
Okay, are there any questions? No, you're off the hook. Thank you,
Thank you,
Delegate
Madam Chair.
Harris.
Thank you, committee.
That concludes the hearing on House Bill 253. Oh, no, it does not conclude it. I apologize. Mr. Lang is signed up as unfavorable.
Madam Chair, fellow members, since you don't have questions, I have a few questions. Hopefully that you can ask the sponsors and some others what will happen. How would the board know that in the pretrial detention facility will receive the absentee ballot and that the intended recipient actually has voted? What prevents an employee or another prisoner from intercepting the ballot, vote and sign the intended recipient's name with no signature verification requirements? Who would know the difference? Additionally, what would prevent someone else from doing the voting and perhaps coercing the prisoner to sign it, even if the prisoner had no intention of voting? It would not have requested the ballot if it hadn't been automatically delivered. What is the registration process for changing the address of a voter from his or her previous address to the detention facility address? How long does it take the board to process the change of address? And what, if any, verification process of the request is being done? It took me weeks before my change of address was processed and I received my new voter ID card. How long do these voters stay in the pretrial detention facility? And how many might be released or moved elsewhere before the ballot arrives? What happens to these ballots if the voter is no longer at the facility? And would you be able to ask the sponsor, the members of the Board of Elections and the facility to describe the controls over this process? They say the road to hell is paved with good intentions. Well, no one wants to deprive eligible people from voting because they're in a difficult situation. We need to make sure these people are actually the ones who are voting. If the voters can process a change of address while at the facility, why not let them request an absentee ballot at the same time? Why resort to an automated issuance instead of only sending ballots to those who request them? Until you guys are sure that there are sufficient chain of custody controls and voter integrity controls at the facility for this process, please vote against this bill.
Any questions for Mr. Lang? Okay, seeing none, thank you very much. That concludes the hearing on House Bill 253. Delegate Fair, we will first take House Bill 215. And you can bring up, are you bringing anyone up with you? Or would you like me to call who I have here? Or are you going to just?
Whoever's testifying, come on up. How are you?
So we have Michelle Politeri, Michelle Whitaker, okay, Jackson Taylor. There is someone without a name for social work advocates for social change. Okay.
There we go.
And then there's one more chair. Nope. You have a virtual that's favorable. Okay.
Thank you. This is my first time before the Ways and Means Committee, so please be, no, I'm just kidding. Chair. Now let's talk about ranked choice voting. All right. Chair Atterbury, Vice Chair Wilkins, and esteemed members of the Ways and Means Committee, Delegate Chris Fair presenting House Bill 215. Democracy works best when voters can directly articulate their preferences, ensuring their voices and opinions are considered when parties select their leaders. HB 215 responds to the principle of considering voters' nuanced preferences. It enables political parties to choose a ranked choice voting contest for presidential primaries starting in 2028. Too often, especially in presidential nomination contests, voters are forced to pick a candidate that does not align entirely with their values for fear of splitting votes between their favorite candidate and a different candidate. Other times, candidates in primaries might drop out, but their names still appear on ballots, leading to votes being cast by constituents that the party will never consider. Ranked choice voting provides a tool to address these challenges. The bill defines ranked choice voting as a simple procedure where voters rank candidates in order of preference, first, second, third, etc., and votes are tabulated to reflect voter preference. If a candidate gets more than 50% in the first round, that candidate wins. If there is no majority, the candidate with the fewest votes is eliminated, and voters who pick that eliminated candidate as their first choice have their second choice counted. This process repeats itself until one candidate receives a majority of the votes. As an example, in a contest between apples, grapes, and oranges as your favorite lunchtime snack, Delegate Griffith ranks apples first, grapes second, and oranges third, while Delegate Roberts over here ranks grapes first, apples second, and oranges third. If apples place last and no choice has received a majority, Delegate Griffith's second choice of grapes would then be considered in the next tally to combine with Delegate Roberts' first choice of grapes, increasing the chances that grapes would reach a majority and win the election, also without having to hold a runoff. Should grapes not reach a majority, then both voters' third choices of oranges would then be counted. This bill is not a mandate. Rather, it allows the individual parties to choose whether to implement ranked choice voting, giving more tools to parties as they consider how to best listen to the voters and nominate their candidates in the most reflective way possible for their preferences. I respectfully ask the Ways and Means Committee for a favorable report of HB 215. Thank you, Madam Chair.
I guess I'm first up then. Good afternoon, Madam Chair and other members of the Ways and Means Committee. For those of you that don't recognize me, I am Jackson Taylor. I've been here a couple times before. I'm here to show support for HB 215 as part of the youth perspective and the independent voter perspective. This bill is so important to me. I made the 2.5-hour drive from my college campus today to come here and sit in front of you and talk on it. First, on the independent voter perspective, it is a fact that when you allow ranked choice voting to be used in the primaries, more independents turn out to vote for candidates and in turn register for parties in the same sense. This has greatly been seen recently with New York's edition of the same type of bill, where after they implemented it, they had the highest voter registration and voter turnout in over 30 years for their primaries. This can be accredited to a few factors. First of which is when you allow ranked choice voting, independents show an increased voter turnout. They had a 17% of people that were previously independent register for parties to vote for these primaries. And also they had a 10% higher increase in their youth turnout on that same election. I know one of the questions that's going to sit with this committee is that of education aspect of this bill and how much work it will be to educate the voters on how to use ranked choice voting. Well, the good news is we can once again look to New York for this and see how well it worked for them. After they conducted their first election, one of their exiting questions was, how would you rate using ranked choice voting? Did you like it? Did you not like it? Almost 100% of people said they understood it, they liked it, and they wanted to keep using it. And for me, the youth perspective on this is I have been using ranked choice voting for the last 4 years in the state of Maryland. All of the student councils that I was a part of, we all used it to elect our SMOPs. So the youth is very familiar with it. And with that being said, I thank you for allowing me the chance to speak on this bill. And with my fingers crossed, I'll say that hopefully this is the only time I have to speak on this bill in front of y'all.
Honorable Chair, Vice Chair, and members of the Ways and Means Committee, thank you very much for this opportunity to speak. I'm Michelle Whitaker. I'm the Executive Director for Ranked Choice Voting Maryland. We're a statewide nonpartisan grassroots organization that is focused on making sure that we're strengthening the voice of voters in our elections in Maryland. I think Delegate Fair did a great job of explaining how ranked choice voting works and what you do, and it is really about the power of the voter. Ranked choice voting is a powerful tool that we can use in Maryland, and instead of limiting our voters' choice, voters can more fully express their preferences for candidates on the ballot. In our daily lives, we make decisions based on choices that are before us. Imagine going to your local coffee shop and ordering your favorite drink. What happens if that drink is not available? If ordering your favorite coffee worked like our winner-take-all elections, you would have no opportunity to choose your next favorite beverage. Now imagine you pre-ordered your favorite drink, and when you got there, the shop said that they're all out of it, but you can't select another because you also ordered early. It would be a bad way to get coffee, and it's a bad way to have your voice heard in an election. We can give a stronger voice and strengthen our democracy. As noted in my written testimony, wasted votes occur when in primary elections when a candidate who's running in that race later drops out of the race. No one's vote should be wasted in our elections, and we see this happen. And in Maryland in particular, 6% of voters in the 2024 election had their vote wasted. We've had millions of votes wasted in the 2020 election. This is a reoccurring thing that happens across the country, and many jurisdictions are looking at this as an option. I hope that you'll consider a favorable report and also know that our tools and the capabilities of our current election system allow for us to use ranked choice voting, as the state director mentioned at a briefing to you. And we have ways to incorporate tabulation that will lower the cost of this for all Marylanders. Thank you.
Good afternoon, Chair Atterbury and the committee, and thank you for your time. I'm here representing Social Work Advocates for Social Change. We are a coalition of MSW students at the University of Maryland School of Social Work that seek to promote equity and justice through public policy. We strongly support HB 215, which would allow the State Board of Elections the option to use ranked choice voting to elect a primary candidate. Ranked choice voting encourages voter participation. Low voter turnout persists in Maryland, with more than 2 million eligible voters sitting out since 2012. That's every year. A study last year highlighted that voters are 17% more likely to show up for municipal elections if they live in an RCV jurisdiction. New York City, as I think was already mentioned, saw a 36% increase in turnout after switching to ranked choice voting. In San Francisco, there's ranked choice voting mayoral contest had more voter participation when compared to 2 higher offices, US Senator and Governor, because those were not ranked choice. Ranked choice can similarly increase voter engagement in Maryland, which gives our Marylanders a voice. Ranked choice voting also combats polarization and encourages diversity in candidates by removing the risk of splitting the party or wasting your vote. Maryland had a total of 100,207 write-ins for president during the most recent election. That's an increase of almost 25,000 when compared to 2020. This is over 100,000 voters who were brave enough to reject our current system, which pushes them to vote for the lesser of 2 evils, and allowed them to vote for who they really believed in. By doing this, they wasted their vote. Ranked choice voting gets a more complete picture of what people really want and gives Marylanders a voice, which makes them show out for voting. It encourages candidates to engage with all voters and reduces polarity, which we've seen both on the Republican side and the Democratic side, where voters feel like they have no choice and thus they don't show up. For this reason, Social Work Advocates for Social Change urges a favorable report on HB 215. Thank you.
Good afternoon. I am Mike Pelletier. I'm a Navy veteran and a volunteer with Veterans for All Voters Maryland. This is a nonpartisan group of veterans mobilized and advocating for election innovation. In 2016, during the presidential primary, I was underway on USS Farragut, a destroyer out of Florida. I was actually the voting assistance officer, among many other duties, because that's how we operate. I had calculated out how long or when I needed to vote, because it takes a while for us to pull back into port, or we have to meet up with another ship, and when are they going to pull back into port? And then finally the overseas mailing process. So I finally filled out my ballot, held it to the last day I could, voted, dropped in the mailbox on board. Then the next day, my selected candidate had dropped out of the race. My vote would no longer truly count. Even worse, the candidate that I voted for was not the one I wanted to vote for. I was participating in what was called strategic voting. I was voting for somebody who I thought had a better shot at winning and was the lesser of 2 evils, as you said, but that was who I needed to vote for as the best shot to carry forward. Had ranked choice voting been in place, my vote still would have counted. I could have voted for my preferred candidate and then let my vote trickle down to the candidate that we had a consensus about. Veterans are more likely to be excluded from these partisan primaries. That's why we're here. We are less likely as veterans to affiliate with a party than our non-veteran peers. So our current election system is disproportionately harming veterans. All Marylanders deserve a better system. This bill is a step towards a better, more representative government. Thank you.
Do we have any questions from the committee? We'll start with Delegate Griffith.
Thank you, Madam Chair, and thanks for being here. Just a couple of questions based upon some of the testimony. So, I'm sorry, ma'am, I missed your name. I apologize.
Sorry, my name's Morgan.
Morgan. So you'd mentioned about New York and increase in voter turnout after they adopted ranked choice voting. What year did they adopt ranked choice voting?
I actually don't have the year in front of me, but there's been a lot of people, it's sort of been trickling in that people have adapted it, because as we're seeing municipalities and states and even countries that have been doing this, I mean, ranked choice voting is not new. They're seeing that it really is having such a positive effect. It is bringing out voters.
Well, I guess my question is, what data, is there any data to make that direct correlation? Because you're attributing higher turnout directly to ranked choice voting, so I'm curious what the data is to support that.
Well, no, you're absolutely accurate that when it comes to data, things like voting, there's a lot of variables. But if you actually refer to my written testimony, there are footnotes and direct correlations to data that does support that.
And as far as the couple of the points, and this is for really anybody on the panel, it was talked about not having a candidate that you would prefer on the ballot. So even if there's a candidate you don't particularly want to support, right? But you have the best bad choice, so to speak. How would ranked choice voting affect that? Because you still have to choose, even the best bad candidate on the ballot, even if you don't like any of them. So how would ranked choice voting affect that at all?
Yes, I'd like to answer those. Michelle Whitaker again with Ranked Choice Voting Maryland. So just on your first point regarding when New York, it was they did it for their 2022 elections, where they saw both an increase in turnout and were using ranked choice voting.
So that was
There's
also
data,
tied to mail-in
independent
ballots
data,
and stuff.
but just wanted to share that.
So that was probably as a result also of mail-in balloting, and we saw spikes in Maryland and other states as a result of that.
I can happily share more data on that piece for that component. And I'll say in terms of what a voter does with a ranked ballot, they have more options, and their options are to rank as many or as few candidates as they choose. So in a case where there's really just one candidate that they prefer, they can still just say, this is my top choice, that is the only person I'm ranking on my ballot. If there are multiple candidates that they prefer, they can select those candidates in the order of their preference, but they don't have to rank all of the candidates on the ballot. So if there's truly someone that they like, I do not prefer this candidate and I don't want to vote for them, they don't have to rank them. It's just like we do in our current system, but you have the preferences there. Does that help answer your question in terms of if there's someone that they don't like, they don't have to vote for them or they don't have to rank them?
So it actually may put them at an unfair disadvantage. So if it's 2 people on the ballot or there's 4 people on the ballot, I can choose my one. But if I don't like this person, I could choose 3 against 1 and set them up for more failure then in that case.
So you eliminate the strategic voting in this because it's really up to the voters' preferences, and you are selecting, this is my top candidate. And as Delegate Fair was explaining with just the tabulation process, you're tabulating all first choices in the first round. So if there's a candidate that does not, or if there's a candidate that wins a majority, the election is over and you've elected someone. If no one receives that majority, that's when you're going to what's called an instant runoff process, and you're looking at the next choice available to about once you've eliminated the lowest, the candidate who receives the fewest number. So it does not benefit a voter to say, I'm going to try and game the system and do not vote for my true intentions, because if you're trying to get your candidate to be counted, if you're trying to get your voice to be counted and elect your candidate, you need to be putting your preferences out there for the candidates you want, not trying to game it for something else, which is what we have happen in our current system often.
I think my final question is tied to the point of if someone drops off the ballot and you've already submitted your ballot, that vote potentially not counting. I guess, do we know how many times that happens, how many candidates have fallen off the ballot between the time someone casts the ballot and then the ballots are counted? Do you know how frequent that is?
Let's go. I don't want to speak to the individual, that identical situation, but I do want to highlight that, especially with the increase in presidential primaries of the number of candidates running, I think in the last go around, we're seeing upwards of 18 to 20 plus candidates running in these presidential primaries. You have individuals who never even get the opportunity to consider their candidate that they truly wanted, because by the time the primary reaches their state, essentially the election's already decided.
Well,
But that voter,
that's definitely Maryland.
but that definitely is one of the reasons for ranked choice voting. Because now I have to make the decision as a voter, do I want to vote for the candidate that the party that it's very clear is on track to become our nominee, or do I want to vote my essentially quote unquote protest vote, or my wasted vote for the person that's dropped out of the race already? Or with ranked choice voting, what it does is allow us to do essentially both. We can now vote for our values, the candidate that we really wanted, even though they've dropped out because they're still on our ballot. However, I can also rank them within the score of other candidates, including the one that maybe is the nominee for from that individual party. I can also vote for them in that process as well. So, but it's just based on where I rank them at.
I just have some concerns with one person, one vote, and we make our statements when we vote on the candidate we prefer or feel is the most likely to win. So I think that's a good political statement. But thank you for the bill. I appreciate it. Thank you for answering my questions.
Thank you, Delegate.
Delegate Plakovich-Carr.
Thank you, Madam Chair. Thank you, Delegate Fair, for the bill. I think this question is for Ms. Whitaker. I appreciate in the bill it specifies that there would need to be a voter education campaign, and I wonder if you can speak to, in other jurisdictions that have adopted ranked choice voting, was that a part that was mandated, and is there anywhere that did that voter education campaign especially well that we might look to as models?
Thank you for the question. I'll say that in all jurisdictions that have used ranked choice voting, they've had different varying versions of voter engagement as well as candidate engagement. In most recent jurisdictions like New York, Alaska, Maine that have introduced it and used it, they've had robust campaigns that are led by the Board of Elections, and then additional groups who support the measure also add in terms of helping to get the word out. And we've seen that even happen if you look at other measures like vote by mail, where you're taking the lead of the Board of Elections in terms of here's the process and understanding it, and many civic groups do their duty as well to reach out and make sure that they're informing their communities. So it's led by what the Board of Elections does to make sure that they're educating their election judges, that all administrators are familiar with the process, that there's clear communication prior to the election about what the new ballots will look like, how your vote is counted, all of that sort of information. But then we know that civic groups take a lot of initiative when they have these new reforms, and many of these groups may be part of that process to make sure that all communities are aware of how they can participate in the election and what changes are happening.
Okay. Delegate Merrick North, no question? Thank you very much. Do we have Nancy Soring? Is she here virtually? Oh, okay. Delegate Wims?
Thank you, Madam Chair. Press my button late. I just have a quick question for anyone there. Would the ranked choice voting help those with more money or those who are publicly funded? Could anyone ask that question?
Thank you for that question. I like the way you're posing that in terms of just where the benefit lies. The benefit lies in the voter, and the voter having the strongest options to really select the candidates who are representing their community. So you can, with public financing, a candidate, if they're doing the work to go out in the community and reach voters, they're going to earn the broadest support, and they can win in a ranked choice voting election. If you have someone who is maybe using a more traditional system, they may be able to get the word out, but again, it's going to level the playing field because you have anyone can participate and you're not doing negative campaigning. That's one of the main benefits of ranked choice voting, is that you have more civil campaigns because you can't trash your opponents. Candidates can't trash their opponents. They need to earn those additional support from other voters. And so you'll have more healthier campaigns, but I think it benefits the voter primarily. I don't think there are any reports, specifically any studies that have been on the comparison of publicly financed and other candidates, but that's an interesting thing to study, and I appreciate the question.
Okay, thank you all very much for being here. Ms. Soring, for 2 minutes, please. You're on mute, Ms. Soring.
Thank you, Chair Atterbury and Vice Chair Wilkins and Delegate Farr for introducing this bill. I'm Nancy Soring, representing the League of Women Voters of Maryland. We have supported ranked choice voting for many years because, as the others have stated, we believe it gives a better representation of the voters' true feelings, and voting, as you know, is very sacred to the League's mission. A couple things I will add, I won't say in order not to repeat, is that number one, this bill offers time to actually do the educational campaign and prepare voters for how to vote by ranked choice voting, because it won't actually be implemented till 2028. And additionally, it was talked about this public education campaign and whether or not other groups would be part of that. And I can guarantee you, since voter education is central to our mission, we would definitely help spread the word about how to do ranked choice voting. I just want to say, I hope we can move forward to this, because I think this would be a wonderful opportunity during election when we're bound to have a multitude of candidates, especially since there will be no incumbent presidential candidate, that this would be the perfect time to understand how the system actually works, and actually you end up with something, with a candidate who wins, who is gained more approval from the most voters. Thank you.
Thank you. Any questions for Ms. Soring? Okay, seeing none, thank you all for being here. We do have two unfavorables, Alan Lang, and then if we can check and see if Jade Chang is with us virtually. Here, we do have two unfavorable. Okay, Mr. Lang, for 2 minutes, please.
Madam Chair, fellow members, I'm against the bill. I sent all of you 3 different studies. 2 of them were compared and contrasted. The other was a study by the University of Minnesota that went through some of the claims that wanted, from their study, that RCV does not reduce the polarization of political parties. Second, it didn't increase the diversity of elected officials. And third, it did not necessarily increase voter turnout and engagement of voters of color. Now, this study was in 2023, and it did not decrease negative campaigning. So I'm concerned about some of the examples that in all the studies I've read, you had to vote for every candidate. You just couldn't pick one and ignore the others. If you did that, your vote was discounted and discarded. And there were quite a few conditions of that where the people didn't understand, or with a long list of multiple voters, they never went to page 2, skipped one, and had their votes discounted. In the examples shown, the person who comes in last and by number of first place votes would be eliminated. And then, as I understand, that person could have had the most second place votes, but that person's been eliminated from contention. Of the idea is to get a consensus by doing it purely on first place votes. You don't do that. For example, in sports, the most valuable player, there's 5 points for first, 3 for second, and 1 for third. You can win by coming in second in first place by getting more second places. This process wouldn't do that. So I encourage you to read the material I sent you before voting for this bill. Thank you.
Thank you. Any questions for Mr. Lang? Okay, Ms. Chang, for 2 minutes, please.
Hello, can you guys hear me?
Yes, go ahead.
Okay, great. Good afternoon. Thanks for the opportunity for me to testify here. I don't know too much about how this RCV works in terms of, favoring certain candidates or not. But I mean, let's talk about the cost. I don't see the cost, the estimate of the cost for implementing this new system. I know that there was a bill for the Board of Education elections for Howard County. I think it's the last year. The ranked choice voting has been withdrawn as people were opposed to it. The estimate cost, even just to implement the RCV ranking just for the Board of Education election and just for a county, Howard County, was estimated to be almost $1 million. It's $893,000 just for the first year. Imagine how much it's going to cost for a presidential nomination and certification of election for the whole state. I don't know, are we talking about multiple millions, billions? I mean, the state of Maryland is in a $2.7 billion of deficits. Why are we doing this now when we have such a tremendous deficits? We need money to do other more things. And why are we prioritizing this RCV right now? I don't get it. You know, kids need more teachers. Schools needs more money for renovations and improvement and technologies. And we have so much more we need to do.
Thank you, Ms. Chang.
Is it 2 minutes already?
Yes, it goes by quick when you have a lot to say.
Okay, I'm sorry, but thank you.
That's okay. Let's see if there are any questions for you. And I don't see any. Thank you very much. That concludes the hearing on House Bill 215. Delegate Fair, House Bill 167.
Why do I have a sneaking suspicion I'm up here by myself for this one? All right. Anybody? No. Okay. Chair, am I okay to go, Madam Chair? Okay, thank you. Chair Atterbury, Vice Chair Wilkins, and esteemed members of the Ways and Means Committee, Delegate Chris Fair, presenting House Bill 167, a modest yet crucial adjustment to the Maryland's motor vehicle excise rate from the current 6% to 6.75%. This increase reflects the changes in revenues flowing to the Transportation Trust Fund as vehicle technology changes and road maintenance strategies adapt to new realities. These funds are not numbers on a balance sheet. They represent tangible improvements in the quality of transportation and thus the quality of living, working, and recreation for all Marylanders. Increasing this rate will ensure funding for local highway projects, better maintained roads, enhanced safety measures, and more user-oriented modern transportation infrastructure. Simply put, this impacts every district in our state. This rate has remained unchanged for nearly 20 years, and since that time, the demands and complexity of our transportation infrastructure have evolved. Additional revenue from this increase enables Maryland to meet the growing and changing needs, including improvements that have been deferred for far, far too long. This adjustment ensures that we remain competitive while securing the funds needed to invest in our infrastructure, ultimately benefiting residents who use that transportation infrastructure by saving them vehicle repair costs due to damage caused by crumbling infrastructure. HB 167 invests in Maryland's future, recognizing evolving transportation realities, enhances the safety and efficiency of our transportation network, and ensures our infrastructure meets the needs of our citizens now and in the years to come. I humbly request a favorable report on HB 167's investment in Maryland's transportation system. Thank you so much, Madam Chair.
Thank you. Are there any questions for Delegate Fair? Okay, seeing none. Thank you, Delegate Fair. We have several folks signed up to testify unfavorable. Franz Schneiderman, Alan Lang, Peter Kitzmiller, Michael Johansson, and Bernie Marzik.
Thank you, Chair Atterbury, members of the committee, for the opportunity to address this bill. My name is Franz Schneiderman. I work with a group called Consumer Auto Maryland. that works to protect for protection and fair treatment for Maryland drivers and Maryland consumers. And, you know, we're concerned about this bill and oppose this bill because while, you know, I do understand that the state has, you know, important revenue needs and that drivers need an adequately funded transportation system, the cost of car ownership really has exploded over the last decade or so, and it's causing real difficulty for the livelihoods and the ability to make ends meet for so many people. New car costs are now on average more than $47,000. Even a used car, the average cost is better than $25,000. So this tax hike would add about $350 to an average used car transaction, about $200 to an average used car transaction. But, you know, other car costs are also rising very quickly. Car insurance costs are now have risen about 15% a year over the last several years. Average cost of full coverage is now about $2,800, and many people pay a lot more than that. If you live in Baltimore or have a troubled credit history or some other factor, I mean, people are paying on average now more than $500 a month just for used car. The average used car monthly payment is about $520 a month. For used cars, it's about $740 a month. AAA estimates that the cost of owning a new car now is better than $12,000 a year. And this is just making transportation unaffordable for many Marylanders. So, you know, I appreciate the need for revenue, and I think some of the ideas like the delivery fee are really great, you know, innovative ideas, but this, I'm afraid, would add to stress for drivers who really need some relief from those financial stresses. Thank you.
Madam Chair, fellow members, Alan Lang from Harwood. I'm against this bill. This increase may seem like a small amount to the sponsor, but this and other bills adding additional fees or taxes is like the proverbial death from 1,000 small cuts. Our governor has said that most of the people in Maryland wouldn't be subjected to more taxes. This seems to go against what he's been telling us. Rather than finding additional revenue sources, perhaps some of these major transportation and educational projects you're trying to fund should be delayed or reduced. We're already taxed enough, so increasing our taxes while we're still facing rising health care, rising housing, energy, grocery costs is making the land of pleasant living that much less enjoyable. If this continues, you're going to be driving more and more of us, especially those of us of retirement age, out of the state to find a better, less taxable state. Thank you.
Madam Chair, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchised new car and truck dealers and their 22,000 employees across the state of Maryland. Here today in opposition to House Bill 167. I want to speak to the vehicle affordability issue and give you some specific numbers. In 2019, the average price of a new car in the state of Maryland was $37,000. At the end of 2024, it was $49,000. Used cars have gone up even more dramatically. In 2019, the average used car price was $20,000. In 2024, it was $37,000. So it's almost doubled. At the same time, interest rates, which prior to COVID were 2 to 4%, are now 6 to 9%. The average monthly new car payment in the United States is $757. Vehicle affordability is one of the biggest issues facing our industry. The dealers are not unaware of the Transportation Trust Fund issues the state of Maryland is facing. We need good roads for our customers, and we live here too. That's why we supported the 50% increase in registration fees last year, which was indexed for inflation. And I want to point out that every year since 2011, vehicle excise tax revenues to the trust fund have increased. There is a built-in inflation factor on the vehicle excise tax. Our my dealers and our customers are paying more than their fair share of funding for the Transportation Trust Fund. And in closing, I heard the sponsor talk about this is going to make us more competitive. It's going to do exactly the opposite. On a $60,000 car under this proposal, you would pay $4,050 in tax, $281 title and registration fees for a total of $4,331. That exact same car in Virginia would be $2,624, almost more than a $2,000, a little less than $2,000 difference. So for those reasons, we'd ask for an unfavorable report.
Madam Chair, I'm Mike Johansson on behalf of the Washington Area New Auto Dealers Association. We appreciate, the sponsors' efforts. However, when you describe this as a modest tax increase, 0.75 seems small, but it's actually a 12.5% increase in car taxes. That's on a base of about $1 billion a year that is actually collected in excise taxes across the state. So that's why it's $150 million impact on an industry that's already giving more. In the last 5 years, pre-COVID to 2024, titling tax revenues to the state of Maryland went up 15%. Peter mentioned for the first time in its history, Maryland last year indexed the registration fee because it was set at a flat amount and, it didn't grow over time. The gas tax for the first time, 12 years ago was actually indexed, so that would grow. But car taxes have always been rising, no matter the economic situation, 32% in 10 years. So we feel we're paying our fair share. And when it comes to, well, where's the money going to go? The Department of Fiscal Legislative Services, I'm using an old name, did a chart that showed between the January CTP of 2024 and 2025, every MDOT agency gets more money except highways. In fact, the biggest gainer of total funding is transit. The other chart that's quite convincing from the Department of Legislative Services is the amount of money that's spent on transit growing its share of all MDOT sources while highways is going down. So we do oppose the measure. We think there are other ways to raise funds for the Transportation Trust Fund for roads in particular, but this bill doesn't do that. The governor's proposal to repeal the trade difference, which happens to be the same amount of money, about $140 to $150 million, is also something we oppose on the same grounds. Thank you, Madam Chair.
Madam Chair, members of the committee, Bernie Marzik with Cornerstone Government Affairs here today on behalf of the Maryland Recreational Vehicle Dealers Association. Just a little bit of background, the RV Dealers Association was formed in 1965. It's comprised of 7 dealers from around the state. Those dealers employ over 300 workers. They're located in Anne Arundel, Frederick, Hartford, Queen Anne's, and St. Mary's counties. We are here urging an unfavorable report on this bill due to the impact it would have on the competitive nature of the business. You heard from the previous witnesses about the increase in the rate. I think you all know very well, Maryland's geography puts our surrounding states much closer to potential customers for, in this case, RV dealers, where they have the ability to very quickly go across state lines and pay lower taxes on those vehicles. I think increasing this rate would really hurt our businesses as they put through. And as Mike mentioned as well, this coupled with the proposal in the BRFA by the governor on trade-in of vehicles, which you all will be hearing shortly, would also have a negative impact. So taken together, we'd urge you to vote unfavorable on both of those. Thank you very much.
Thank you. We have questions. We'll start with Delegate Buckle.
Thank you, Madam Chair. And I think this document, I don't know who did this, the Automobile Dealers Association or WNADA, maybe Mr. Johansson said that. So all of this money going to the Transportation Trust Fund, none of it's going to more roads by percentage from what I can see. If this is the same document you're referring to, under the administration's current proposals, we will have the lowest amount of Transportation Trust Fund money this century spent on roads, despite the fact that we will be increasing the costs on everybody who buys cars to use the roads. Is that fair?
Correct. So the $400 million that's in the governor's new CTP and the registration fee increases from last year, which would be added to that, the DLS estimate shows that transit gets $1 billion more in the proposed 6-year period starting today, and highways get $500 million less. So while the user fees on registration fees, the repeal of the trade difference, the delivery fee, the recipient of funding is actually transit.
Right.
The other thing that's mentioned in the CTP, which was just released at the same time the budget was released, there's 300 new jobs across the MDOT. 275 of those jobs are for transit, and across all the other agencies of MDOT, there's only 25 new jobs.
Shocker. So, yeah, I'm just reading this. I mean, this is correct. It appears to be. I think it's straight out of the DLS impartial analysis. The highest percentage we'll have spent this century of the Transportation Trust Fund will be on mass transit, and the lowest percentage on roads. And we're going to pay for it through no actual increases on mass transit users, and all of the increases will be on people who use the roads and the cars, including they'd get even more money under this misguided bill. Is that right?
That's what it appears.
That's beyond disturbing. Thank you.
Delegate Hartman.
Thank you, Madam Chair. Someone who trades out of cars pretty frequently, there's a lot going on this session with car dealers and the potential impact. So seeing that it seems like money is just being taken from those driving the vehicles, using the cars, taxed to fund public transportation. And it's going to be at the cost of not only those driving the vehicles, but the dealers. So my concern is I trade in a vehicle because the tax credit is so large. If we lose that tax credit and then add another 0.75%, do you know what the difference is in, like, if I trade in a vehicle, what it's sold for, and how long that would, that's a product we're really creating. So my concern is we're taking away, we're going to have everybody trading in their vehicle, or not trading in their vehicle, selling it privately, and hurting the dealers by them losing that secondary product of creating a used vehicle to put on their lot.
So based on average numbers, if a new car sells for $50,000, the average trade-in today is $20,000. So if you trade it in, you basically get the benefit of a reduction of tax of $1,200. But the state's not losing money because a $20,000 trade in the car business is a great car to put on your used car lot and sell. After you put about $1,000 into it, maybe you're going to sell it for 22 or 23, whatever you can get for it. So the 6% tax is actually more than the credit when you trade in your car. And it keeps that cycle going. It keeps those trades going. A new car dealer may get 1,000 new cars a year to sell, but they're selling about 1,000 used cars on that same lot. So that economic activity is extraordinarily beneficial to the trust fund and titling tax collectors, whereas if you sell it on the private market, you may not be paying the full titling tax when you report it to MVA, right, because that system's less secure. But if you sell it at the dealership when you trade it in, we're collecting the tax on the new car. We're usually collecting tax pretty quickly on the used car, and the state trust fund is getting all that money.
That's a good point about the credibility of the sale of the used vehicle. But the question really, like, what's the difference in, is there a percent markup? Is it typically 10% or something that a dealer tries to make when you're trading in a vehicle? I'm trying to figure out, I always traded them in because of that credit. Now you're taking 6.75% potentially with all the proposed bills. So if a $50,000 vehicle, it's at more than $3,000 in taxes. Mm-hmm. So would it make more sense for me to sell that privately, or is there still a margin? You understand it?
Right. Well, I think certainly the trade in credit is the incentive to get people to bring their car in, and without that, I think you're absolutely correct. We're going to see less of that. Some people will still do it. They don't want to sell the car privately, but again, used cars are kind of the lubricant that keeps our business going. Except for the 2-year period of COVID, we make less than $200 on new cars at this point. That's kind of and we're back to that now. We're back to the normal market. So we make our money on used cars and parts and service, and those trades are critical. And again, as Mr. Johansson pointed out, the state makes more money if you trade the car in, and we put $2,000 to recondition it, put it on the lot and resell it, you're going to get the 6%. So they're not losing money because of the trade-in credit. I would argue that they're coming out ahead.
Thank you.
Okay, are there any other questions? Okay, seeing none, thank you very much.
Thank you.
That concludes the hearing on House Bill 167. And for our final bill of the day, to round out Delegate Fair Day, Delegate Fair.
Please. According to one of those presenters, it's FAR. It's pronounced FAR Day. All right. Yep. It's exciting. All right. Thank you, Chair Atterbury, Vice Chair Wilkins, and esteemed members of the Ways and Means Committee. For the last time today, I promise. Delegate Chris Fair presenting House Bill 23, enabling counties in Baltimore City to create a differential property tax rate for SDAT-defined subclasses of commercial real property. I'm bringing this MACO priority bill forward on behalf of numerous counties who have asked for this authority, honoring their requests of the General Assembly to allow local control for governments as they provide essential services to our constituents. Counties across our state have vastly different economies, each with unique challenges and opportunities. This bill acknowledges that reality and provides counties with similar flexibility as our local municipalities have to set different property tax rates in their jurisdictions. This enabling tool may bolster counties' budgets as they deliver critical services in line with state policies. Additionally, any new tool for local authorities should have robust safeguards to ensure proper implementation. First and foremost, Marylanders' residential property tax rate cannot increase because of this bill. I want to repeat that. Marylanders' residential property tax rate cannot increase because of this bill. HB 23 only applies to the differential rates for SDAT-defined commercial property subclasses. Further, it mandates a tax credit for the residential portion of any mixed-use property for those commercial square footage, for whose commercial square footage is subject to that increase. For small businesses with 15 or fewer employees, jurisdictions are also empowered to give a tax credit on any rate increase to ensure that small businesses are protected and remain competitive. HB 23 also mandates that all revenue raised by the counties under this bill must go toward two areas of government that connect all of our communities and improve everyone's quality of life, and that is transportation and education. Finally, there is a 12.5% cap to affirm the Maryland General Assembly's intent to grant limited authority to raise commercial property tax rates. The cap ensures that jurisdictions have adequate flexibility to raise specific revenues for important projects, but that flexibility comes with limits to prevent any abuse. If enabled, this bill will be a new tool for local jurisdictions to fund essential products and improve government services for all residents, especially crucial in challenging fiscal times we find ourselves in. This pragmatic approach to local revenues acknowledges that our county officials are best positioned to make these rate decisions locally. We know one-size-fits-all policies generally do not work. Local officials know their communities best and are the people equipped to guide them through those opportunities and challenges. Our job at the state level today is to remove the red tape and allow them to serve their jurisdictions more effectively. I ask for a favorable report on HB 23. Thank you, Madam Chair.
All right, thank you so much, Chair Atterbury, Vice Chair Wilkins, and members of the Ways and Means Committee for the opportunity to speak on HB 23. For the record, I'm Jessica Fitzwater, the County Executive for Frederick County. I want to thank my delegate, Delegate Fair, and the other sponsors of this, and also recognize Delegate Miller, also from Frederick. I'm here today to speak to the importance of expanding local authority to set special tax rates for subclasses of property, because I believe this is a crucial tool for local leaders like myself to raise the revenue required to finance the infrastructure and services our communities need. I commend the Ways and Means Committee and their staff for the robust and comprehensive work that was done throughout 2024 to evaluate this issue and to craft the language that is in front of you today. As you know, currently, local governments have limited tools to raise the revenue, and with the rising cost of housing, we face pressure from our constituents to raise that revenue without increasing their property taxes. At the same time, growing transportation infrastructure demands and evolving education needs require consistent and continual investment. As the county executive of the fastest growing county in Maryland, I feel these two immovable forces every day, especially during our own budget season. HB 23 will give county leaders like me and my colleagues on the county council who are deeply committed to the promises of Blueprint for Maryland's future and the needs of our transportation infrastructure another tool to raise revenues without inequitably impacting our constituents. I believe the guardrails that are incorporated into this bill will ensure that this tool is used effectively and responsibly while providing local government with the flexibility to cater the special rates to the unique landscape of their communities. Thank you so much for your consideration of HB 23. Thank you to Delegate Fair for your leadership on this initiative, and I urge you to please advance this bill with a favorable report. Thank you.
All right. Thank you, Chairwoman Atterbury and the whole committee here. I'm Anne Arundel County Executive Stuart Pittman, and I won't say things that have been said before, but I will note that it's interesting that this bill is supported by the Maryland Association of Counties. This and some other bills that allow counties some flexibility in how we raise revenue did not used to always be supported by the whole organization. There was some partisan divide. There were smaller counties versus larger counties. This is supported because it's not a mandate that anybody raise any taxes or any revenue. It simply allows those who are willing to take that political risk, it could be, or who have that need to meet that need. I think you all know what we're responsible for funding, and I think you know that municipalities in Maryland already have this authority. So I was very surprised to learn that if you're a municipality, you can have variable rates on your property taxes, but if you're a county, you cannot. We do transportation, we do education, and we need to figure out ways to fund them. In Anne Arundel County, I don't know whether or not we would use this. We tax 98 cents per $100 in our county, which is one of the lower in the state. If we got this 12.5 cents, the maximum we could do would be 12.5 cents on the commercial property with the exemption for the small businesses. Then we'd be at about $1.10. So still lower than most of our neighbors. I encourage you to allow counties to have the authority to raise revenue in creative ways, and this is one that's been done in many places. In fact, in Virginia, it's required that you do your property taxes for commercial properties at a higher rate. It's one of the reasons why they have a better transportation network than we do. So I encourage you to support this bill, and I promise you that you'll see some real growth in economic development in Maryland if you do it, and that it won't be on the backs of our homeowners.
Thank you very much, Madam Chair, members of the Ways and Means Committee. My name is Rich Madalino. I'm the Chief Administrative Officer of the Montgomery County Government. I'm here representing County Executive Mark Eldridge. For a moment, I'm a former member of the House of Delegates and the State Senate, but I was also a staff person here. And in fact, my very first presentation days after finishing college was before the Ways and Means Committee. So it's always a special honor to be before your committee to talk. So they were not that nice that day, so I really appreciate that. But I forgot all of my notes at the back of the room and couldn't even remember my name. So things have changed over 35 years. I'm here to ask for your support for this enabling legislation for us to be allowed to do this. As County Executive Pittman just referenced, the state of Virginia gave their Northern Virginia counties and their Tidewater area counties this authority years ago. As someone who's lived in this area all of my life, used to be the two sides of the river always had very similar infrastructure, very similar growth. In 2010, 2012, in that time frame, the Republican governor of Virginia led an effort to empower Northern Virginia to increase its taxes to build infrastructure. And I think over the last 12 years, as horrible as it is for me to say this, you see the state of Virginia move forward with infrastructure in a way the state of Maryland hasn't been able to do so. We applaud Delegate Fair and his co-sponsors for putting this idea forward because we need the ability to get infrastructure done. If it's not going to happen at the state, it needs to happen county by county so we can make these investments. It's such an honor to be here with the Frederick County Executive, Ms. Fitzwater, because there are so many projects we need to do together in order to deal with the congestion that we live in every day. This is a small tool that will help us do it. But again, as both county executives said, these are decisions ultimately that would be at the local level. You are simply enabling us to move forward with these investments. So with that in mind, I would ask for your favorable consideration for this very important legislation, and to thank you all for working on this during the summer and coming forward with a plan that is very workable and just treats counties the same way all of the municipal governments are already treated. Thank you very much, Madam Chair.
And thank you, Madam Chair, and members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of the bill. You have my written testimony. I don't want to repeat all of the wonderful things that have been said. I just will point out that 2/3 of Marylanders live in a county with the maximum local income tax rate. That means that the only way counties are asked to fund the blueprint is to raise property taxes. Nobody likes when we raise property taxes. It's inequitable, it's regressive, and quite frankly, it will only exacerbate the affordable housing crisis. We cannot be asked to just rely on property taxes to fund the blueprint. That pulls levers in other places, it exacerbates the housing crisis, and we need more flexibility. We'll have bills about income tax, but this is a great bill. I think that you heard the differences between Maryland and Virginia and the infrastructure investment, and so I think this will enable counties to make those kind of investments. I know that you'll have testimony in opposition to this bill. I know people will come up behind us and oppose this bill, but conversations we've had with the business community always yield two things. They want good schools, they want good infrastructure. I'm not sure what else they want us to do. We want to make these investments. The state is not in the place to make these investments. If we want to drive economic development and growth, we need more options. I understand nobody wants to pay higher taxes, but the idea here is that we can make these taxes so that they benefit the people who will benefit from them, right, from the investment. And so not to hit everybody with some broad tax increase, but actually to try and work with the business community to tailor these tax rates to the people who will benefit from them the most, and they're going to get a good ROI. We know that from other case studies in other states. So with that, again, I don't want to repeat anything else. We would ask for a favorable report, and I'm happy to take questions.
Thank you. Can we have Sam Zwirling come up, and then we'll do questions. Thank you. Just swap out real quick.
Good afternoon, members of the committee. Samantha Zwirling here on behalf of the Maryland State Education Association, representing 75,000 educators across the state of Maryland. I've been here before this committee talking about local revenue. As you all know, schools are funded not only on the state level, but also need county revenues. And we have many of our counties who are looking to raise revenue in a way that does not disproportionately impact working people. And so this bill really does fit for the values that MSCA has on supporting revenue. And while we're also engaged in K through 12 funding, we also represent workers at our community colleges, and we want to make sure that there's funding there and we're funding the continuum of education. So MSCA urges a favorable report on this bill. Thank you very much.
Thank you, and we will start with Delegate Buckle.
Thanks. Thank you, Madam Chair. And I understand you guys are in a tough position because we just keep saying you'd spend more and more and more money, which that's our problem. That's our problem, and I understand you would keep spending, but I just took a look, 15 minutes each one of your 3 jurisdictions, and what you would potentially get if you went to the max. I appreciate County Executive Pittman saying he's not sure if they will or not. I'm pretty sure he will, because I think my friend, former Senator Madaleno, kind of just said, let the cat out of the bag. We need this. We want this. We're going to do this. And so I looked. So Montgomery County's budget, $7.1 billion. You went up from 6.8 to 7.1. I don't know what you're going to here in 2025. That's what you went up 300 and some million. If you impose this tax, you'd get an extra $51 million, 51 point something, be less than 1%, less than 1%. You just went up 300 million in a year, and now you want to get 51 million. Frederick County, 982 million. You'd get 9 million maximum from this. It would be well less than 1% of what your operating budget is now. And you increased your budget last year by 10.1%, according to your own chief administrative and financial officer. You're increasing your local government budgets 5, 10, 15% per year. And in Anne Arundel County, you went from 2.1 billion in 23 to 2.3 billion last year. You went up 200 and some million. If you applied the principles of this bill to the maximum, they'd get you $23 million, less than 1%. I don't think that with a straight face we can say that this bill is going to enable you to do the type of transit systems that you're talking about. It's not going to enable you to pay the blueprint costs that we've put upon you. I don't think you're all three very intelligent people, elected people, appointed people. I know Senator Madaleno is smarter than me. I know that for a fact. I've had many conversations with him. But I think it's disingenuous to suggest that somehow what we have is a tax problem. We don't have enough revenue in these jurisdictions because we're spending more money than we've ever spent. And it's going up, 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 up. And I guess my question is, at what point in time does it become self-defeating when the business community and others tell you, the people who own a lot of these commercial property buildings, hey, we're out, we're just out, we're out. We don't want to develop anymore, we want to sell it. I looked at a piece of paper that I think AOBA or NAOP or one of the other 55,000 acronyms that all these businesses have, they gave us a sheet that showed, I think it was tied mainly to Montgomery County, about the fact that commercial buildings in Montgomery County are selling for far less than their assessed price. They're selling for less than what people bought them for 5 and 10 and 15 years ago. I know it's happening in Baltimore City. I used to work in a building that I think Peter Angelos bought for around $100 million that his heirs just sold for $20-some million downtown. Can you really suggest to us that this bill, putting more, this incremental tax burden, is going to produce all these things that you say that it'll produce? And any of you. I mean, I'm just walking, I'm not a numbers guy. I went to law school to avoid the math, but math's pretty glaring that we're just spending more than ever and that this is going to be a trickle at best.
I'm not sure which one of us you wanted to respond.
Whoever feels like it.
So just 2 points. One, the increase, partially of the increase in the budget that you saw in our budget last year is because we took a drastic measure to actually raise our property taxes by 5 cents, which the county had not done for over a decade. The revenue from that is going directly into a special fund in our capital budget, specifically for our aging schools, because we have a school construction problem in Frederick County. And our residents were in favor. We have more people coming out to speak in favor of that property tax increase than against it, and it passed through our county council because we're dedicating the revenue to our schools. So we are trying to responsibly use the tools that we have, but we cannot continue to raise property taxes on the backs of our residents. And so this is a tool that that could be available to counties that we would be able to have as an option. And 2 points to that. One, this is just enabling. I can tell you that in counties like Frederick County, if this passes and we decide to come up with a proposal that uses pieces of this, it will be controversial. It will require a lot of community input and a lot of debate by our county council. But that's where those discussions should be happening, because each of our counties are so different with different needs, and we have our own public processes that we can go through to make sure that we're doing what the community sees that we should. Right now, we don't have enough tools. And the last thing I'll say is I don't think any, or at least in my testimony, I'm not trying to say that this is going to solve all of our problems. There are a lot of bills this session that are all just small tools to add to our toolkit to try to make sure that we are meeting the needs of our community, and this is just one of them. None of them are going to solve every one of our issues.
But all of them are incremental tax increase. I guess that's my problem, is what I keep hearing over and over again is Virginia's doing better than us because they tax people higher. But yet, that's just not true. I mean, you can look it up under most metrics available and find that most of the thriving counties, Loudoun County, Virginia, most of those counties' tax rates, even including on this property, these types of properties would be less. And when you talk to people in Virginia, I was fortunate and unfortunate. I practiced law at a very large law firm in Richmond, Virginia for many years. I know a lot of people who work right across from the State House. And what they'll tell you is they're doing better because they're actually taxing less and because they're providing incentives for businesses in the private sector to grow there, not just government jobs, private sector. And so somebody's getting it wrong. I don't know who it is, but I pray to God it's not us, that we're not the ones who are getting the narrative wrong and saying, if you just let us tax you more, we'll do better, when our opponents are saying, our opponents, that's what they are. They're our competitors across the river. So I appreciate that perspective. Obviously I'm not going to be in voting in favor of the bill. Sorry, Delegate Fair, my friend, if it goes that far. But I appreciate you guys coming in and being honest about the financial issues.
Delegate, and if I could just comment.
Sure.
And just as a philosophical discussion, I think that it's important that there is plenty of, I'm sure we can all find tons of research all over the place about these issues, but the research that my team has dug up repeatedly has stressed that businesses are looking for areas to invest in that have invested in their infrastructure. I mean, it's been absolutely, it's been shown time and time again that businesses seek to invest in areas where they have access to strong schools, strong public transportation, and these are the tools that that Virginia has leaned into, at least from our research, that has helped them become this competitive and be able to have kind of the robust business sector that they have.
So,
Question or a very long comment?
Might philosophically be more in favor. Would you be more in favor of imposing an additional sales tax on economic activity in your jurisdiction? So it's 6% for me. Maybe it's 7% in Frederick or 7.5% in Montgomery County or 8% in here in Annapolis. I would hate that, County Executive Pittman, because I have to buy things sometimes here in Annapolis. But do you think that that would be a potential revenue source for you?
It's always a potential revenue source, but I will tell you that for the folks who only spend a very, very small percentage of their income on the things that they buy versus the folks who spend all of their income on the things that they buy, that sales tax is going to be, it's going to be paid for by the little guy. And so that's why I don't support a sales tax. I would much rather do this. And I don't see the increase in the size of the budgets in local government or state government as necessarily a problem in itself. If you come to one of our budget town halls and you hear from our fraternal order of police and our firefighters and our teachers and all of our residents who are demanding services and they're demanding better pay, they want to be able to live on the wages that they make. It's sometimes a good thing for those numbers to come up. It means that we're providing better pay to our employees and we're providing the services that our residents are asking for.
Thank you for that answer.
Delegate Buckle, when you look at Virginia as a model, you'll see that Northern Virginia has a 6-cent sales tax equivalent to what it is in Maryland. Their structure is the state gets 4.3%. The Northern Virginia, every county gets 0.7%, and then the Northern Virginia counties can have an additional 1 cent, right, which gets them to 6. So, and they dedicate that to transportation. All I can tell you is, don't believe me, believe the chief financial officer of the District of Columbia, a neutral party in the fight between Maryland and Virginia. Mm-hmm. Every year well, not every year, but they put out a regular report assessing what is the business tax level across the multiple jurisdictions. And they create one small company, one large company. How would they be taxed amongst the different jurisdictions? You'll be shocked to learn that the lowest taxes for a business is in Montgomery County, Maryland, followed by Prince George's County, Maryland. Where CNBC and all these ranking entities get it wrong is when you compare state taxes to state taxes, yes, Virginia comes out ahead of Maryland because we have a higher corporate income tax rate in particular. When you throw in the business taxes that Virginia, over the years, has let local governments levy, they have a series of taxes that a business professional occupational license tax that allows their counties to do a gross receipts tax on their businesses that entices. The tax rate on commercial property is 40 cents, 40 cents higher than in Bethesda or Annapolis or Columbia or Frederick. Because how does that work? They've invested every one of those extra dollars into transportation improvements. The Silver Line, widening roads, putting in other infrastructure, which has allowed them to take a huge step forward. It's the same companies that build in Bethesda, build in Tysons, build in DC. They're doing it because they realize that investment in infrastructure has made their land and their projects more valuable. So it's a virtuous cycle that is driving investments into Virginia, even though from a business standpoint, it is higher to do business, higher taxes to do business in Fairfax or in Arlington than it is in Montgomery or Prince George's or Frederick or Anne Arundel.
So you let me know only one last follow-up question. If the question is you're going to take all this money and use it for mass transit, do the counties currently fund mass transit today?
So we operate one of the largest bus systems in the country.
Okay, but that's not the
with a
silver line.
ride-on. But we are pledging this. We are pledging this to do capital improvements, because what Fairfax has done, they have the 12.5-cent tax that brings a steady amount of money. They can bond against that and do hundreds of millions of dollars worth of investment. And I would point out that thanks to all of the decisions that we've made, Montgomery County, Maryland maintains 5,400 lane miles of roads. Fairfax County maintains 10.
Okay.
10 miles.
So you're going to spend it on
Because
roads.
the state of Virginia does it. So we have a huge road network that we have to maintain and continue to build, and that is good for all of us, because that infrastructure means more jobs, more investments, and more tax revenue for us and for the state.
I appreciate your answer. We'll talk later. We're certainly friends. I just can't concur with a lot of it because it seems to miss the target a lot. We're going to spend it on mass transit. We're going to spend it on roads. We're going to spend it on schools. Our schools are ranked higher than Virginia's. If everybody's moving there for the schools, they must not be reading the reports very well. But I appreciate it. Thank you.
Delegate Miller.
Thank you, Madam Chair, and thank you for bringing the bill. I have a couple questions. One, we had our school construction work group in Frederick County. One of the things that was discussed was actually Georgia, and Georgia had an increase to the sales tax, as Delegate Buckle was speaking of. But one of the things that I thought was interesting in how they do it, and it's actually very popular there because it goes to capital funding of local school systems, but they actually have to have it approved by the voters every 5 years. Is that something that would fit in this bill, where we were talking about, the county council, what's going to happen in Frederick, and that there will be a lot of discussion about this bill? Is there any thought to leaving it to the voters to decide and put it on that way?
So I would certainly encourage both Delegate Buckle and yourself to put in a bill to look at the sales tax rate. I think that that's a great opportunity for us at the Ways and Means Committee to evaluate that. You both can feel free to bring that forward. I share the concerns that have already been addressed about the sales tax rate. I will just say that I think that it is the responsibility of our General Assembly to unleash or unlock this tool for our counties. We're not actually doing anything here except literally sending the issue back to the counties for them to then have community meetings and discussions. And as we know, the proper way to handle when there is concern about the decisions that your local county executive and county council make, the answer is an election, that they have to be beholden to the voters in their communities at the end of the day. So if they choose to use this enabling legislation and actually move forward with an idea, they have to then go out to their constituents, their residents in their communities, and explain why they did it, and let the residents decide if they deserve to stay in office because of it.
Yeah, this was actually on the ballot. It's very interesting.
Can I say, Delegate, actually, the voters of Wyoming, a widely liberal state like Wyoming, while voting 110% for Donald Trump, passed a constitutional amendment that allows their local governments to do this, because they saw it was a fair way to raise money and develop.
That's what I'm saying. A fair way would be, to actually ask the voters. So the other one is, when you said for the purpose of funding the approved budget of the County Board of Education, which approved budget would that be? One, are we talking about capital operating? Two, are we talking about approved by county council? Or are we talking about just the budget that's passed by the Board of Education the first time, second time? Which one are we talking about?
Who is that question directed at? I'm sorry.
I guess you, Delegate, for writing the bill.
Yeah, well, no, that's fine.
I'm
I don't know what you're pointing to exactly. Are you pointing to the bill
it's on page
itself?
4, number 2 down in the bill itself. Thank you. Sorry.
Yeah, go ahead, Kevin.
I think it would be the budget approved, and we can clarify this in the bill. I would imagine it'd be the budget approved by the county, the Board of Education's budget, but I'm happy to work with the bill sponsor and the committee to clarify. I'll just say, like, the intent here is that this goes to schools and transit, transportation, roads. So anything we need to do to clarify, that's all well and good. But again, the amount of money that counties are being asked to put forward, and again, we're trying our best to do it as true partners in education. We cannot continue to do it through property tax increases. That's the only tool we have. So I'm happy to clarify. If we need to make any other clarifications on the bill, we're just in a tough spot here. We need some flexibility, please.
I understand that, and we just put other things like in a lockbox or into certain things, so I want to be very, very clear about that and that there's no ambiguity because we've had that happen before.
Absolutely,
So
and I'm happy to follow up, sure. Thank you, Delegate.
Delegate Vogel.
Thank you, Madam Chair. Just very quickly to follow up on Delegate Buckles' point from earlier, and I also did the math by looking at the fiscal note. The $50 million that Montgomery County is getting, right? Obviously, it's still a work in process. The budget for education for this year, the superintendent called for an increase in $300 million. $50 million that you could unlock from through this bill, that's a significant portion of $300 million, right?
Oh, it is.
Yeah.
Although I think it would be safe to say for the county executive that he would use this tool, he would propose the council use this mechanism for infrastructure funding.
Understood, but it's $50 million can make a significant impact in counties' operating revenue, in their revenues and their operating budgets, correct? And infrastructure. Great, thank you.
Okay, seeing no further questions, thank you very much. We have the unfavorables next. Alan Lang. Bob Enton cannot be here. Grayson Wiggins, Brian Anlou, and then we should have Ellen Corin on virtually.
Madam Chair, do you have Bryson Popham on your list?
Good job.
I do not, but have a seat.
For the building owners and managers, that should be.
Oh, yes.
That's me.
Brian, I said Brian Anlou?
Yep, that's me.
That's you, okay. That's fine. And then I think we have somebody with us virtually who will go after everyone here goes. So whoever would like to go first.
Sure, happy to do so. Brian Anlou with the Apartment and Office Building Association of Metropolitan Washington. Good afternoon, Madam Chair, members of the committee. AOBA represents about 23 million square feet of commercial office space in Montgomery and Prince George's counties. We are in opposition to House Bill 23. I want to make a quick point about property taxes being the only way to fund transportation. Counties have actually had the authority to do special taxing districts to fund local taxing improvements since 2010. Montgomery County has one special taxing district in the White Flint area of North Bethesda, and it's only generated about 1/3 of its expected revenue over 10 years. Now is not the time to be taxing the commercial office market more because it's in a state of upheaval due to increased telework and hybrid work schedules that have led to employer downsizing or foregoing office space altogether. This has caused property values to plummet, resulting in decreasing state and county tax revenue. As Delegate Buckle noted, attached to my testimony is a graphic that illustrates how properties have lost, anywhere from commercial properties have lost 30 to 70% of their value since the pandemic. These aren't outliers. The latest vacancy rate numbers for Montgomery County is 18%, a 6% percentage point increase from the pandemic. In Bethesda and Silver Spring, which are right on transit, and as the previous panel noted, next to amenities, very amenity-rich areas, highly desirable, the vacancy rates are actually closer to 20%. This is only going to get worse as long-term leases expire and employers continue to reassess their office needs. One final point about Virginia, you can't just compare county to county. You have to look at the whole tax picture. Virginia has a lower corporate tax rate, a lower fuel energy tax, and lower or no development impact taxes than Montgomery and Prince George's County. And for transportation, they entered into a P3 to expand 495, something that Maryland is not willing to do. Now's not the time to tax our commercial office properties more. Thank you.
Thank you, Madam Chair. Members of the committee, Bryson Popham on behalf of the Building Owners and Managers Association of Greater Baltimore. We are the sister association of Mr. Anlou's client here. Our members manage about 140 million of square feet of office space in central Maryland. You haven't heard much in this hearing really about the state of the commercial office market. Delegate Buckle touched on it earlier. I plan to send every member of this committee tomorrow a link to an article in this week's Wall Street Journal that describes the market in Washington, D.C. Yes, it's not Maryland, but it's right next door. And many of the things that are in that article apply to downtown Baltimore and elsewhere in the state as well. The state of the market is not healthy. This type of legislation will not help that. I would point out that the testimony you heard earlier about this being optional, while technically correct, is not in fact going to be the case. If a local jurisdiction is going to increase this tax, they're going to increase it to the max. And as County Executive Pittman pointed out, that's over a 10% increase in Anne Arundel County alone. So it's going to be a very substantial increase. Don't think either that it won't have a rebound effect on you because when, on the state, because when reassessment time comes up for tax determination purposes, the values of these buildings, which are based on their income, and that includes the cost of the buildings, is going to go down. So it's not going to be a net plus for you. Finally, I would suggest respectfully that in all the bills you've heard this afternoon and other bills, there is usually a nexus between the government service that's being provided and the tax burden that is being proposed. There's no such nexus in this bill. Commercial buildings should not be required to support education expenses. For those reasons, Madam Chair, we'd respectfully request an unfavorable report.
Alan Lang, Harwood, Madam Chair, fellow members, I sit here and watched all our local politicians say, we need another source. Where is all this money going to come from? They say it's not coming from the taxpayers. Where do these businesses get their money? They're going to get it from people who use these services, people who buy their products. We're being taxed. You might want to lie to us and say you're not taxing us, but it's an indirect tax, and you're counting on people's economic lack of knowledge to say that, oh, good, we're taxing the evil corporations. We're not going to tax the people. This bill is going to do that. It's going to drive business out. We're going to lose businesses. People are going to lose their jobs, and there's a bad economy. This is a horrible way. You guys need to cut the expenses instead of finding revenue sources, just like the rest of us are doing. We don't have any, unless we can get second jobs or something to pay for these things, we have no other second. You need to cut the blueprint. You need to cut the red line. Thank you.
Good afternoon, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Chamber of Commerce. It's been a long day, so I'll be brief. I just wanted to address the Virginia comments that you heard on the previous panel. Just to put an exclamation point on it, Virginia's corporate income tax rate is 27% lower than Maryland's. The entire, as Brian said, the entire tax framework there is different and provides more incentives for businesses. This bill, the option here and the tax increase is likely to increase the price of goods. MACO stipulated to that. They said they don't want to raise certain taxes because it'll raise the price of affordable housing. And so what they're telling you instead is they want to raise these taxes, which will increase the price of goods. And when I think of the types of goods here, I think of daycare centers, which could be zoned commercially. Childcare affordability is a big issue right now in Maryland. And so I'm worried that this bill will exacerbate issues like that for residents and for businesses who provide services and goods in the state. Additionally, we need more job growth as a state. I mean, I think everybody here can agree to that. And we were 49th in job growth last year out of the 50 states, 49th. And increasing taxes on businesses and increasing taxes on their office space will limit job growth. I mean, it just will. Again, MACO stipulated to that by talking about different factors and telling you they'd rather do it to industry. And so for those reasons, we are concerned. And then one additional piece that I don't know that anybody touched on regarding these commercial properties, Virginia doesn't have building energy performance standards that just went into effect in the fall and are going to create additional price increases for these properties. And so given all that and the collective regulatory framework that these property owners are dealing with right now, the Chamber has concerns. Thank you, Madam Chair.
Thank you. And do we have the last unfavorable virtually, Ellen Corin? Hi, whenever you're ready, Ms. Corin.
Thank you, Madam Chair, Vice Chair Wilkins, and committee members. My name is Ellen Corin. I'm here today on behalf of the Greater Bethesda Chamber of Commerce, respectfully in opposition to House Bill 23. While we support an appropriately funded education and transportation systems, we have great concerns about this legislation. Montgomery County residents are hit by a significant countywide property tax increase in 2023 in the name of increasing education funding. Now we're looking at enabling localities to add another increase just 2 years after Montgomery County's last. Nothing in this bill prohibits a local jurisdiction from layering this differential tax structure on top of an already existing special taxing district, double taxing residents and businesses. This bill allows for credit against the tax for small businesses. This pushes much of the tax burden then onto larger anchor tenants who are crucial to attract smaller businesses into an area. As you know, small business depends on large business to stay in business. This bill also creates an administrative challenge for the property owner and management side. Many larger properties are subdivided into spaces that house, as defined by this bill, small businesses. Moreover, the General Assembly is considering a number of bills that create new ways of transportation and education. It doesn't make sense to consider HB 23 on its own. We need to take a look at all of these proposals together to come up with the best approach. We've supported and participated in efforts at the local level to try and identify solutions to the challenge, but we don't believe House Bill 23 is the answer. For this reason, we urge an unfavorable vote, and we thank you for considering our testimony and for all you do on behalf of Maryland residents.
Thank you. Committee, are there any questions? Okay, seeing none, thank you all very much.
Thank you, Madam
That
Chair.
concludes the bill hearing on House Bill 23, and that concludes the Ways and Means bill hearings for today. Thank you.